Last may kindly have it day after tomorrow. This is for service of notice. The lower court also ex parte. Here also not serving. Day after tomorrow for paper publication at least. List to the arts.
Lord, sir, this is a commercial appeal. Or this is a commercial. That's a commercial appeal matter.
It's commercial. Per time notice.
That's just it.
Much of it. Yes, please.
That's the
10th month, Anirella. 12th, much. No. Yes. Okay.
now, this is a case where commercial appeal matter. It went to the Supreme Court, and the Supreme Court remanded the matter back to the High Court to decide on merits as explicit. There, my lords, but it is there in the file. It is there in the file. I have the order now. My lords, the date of the order is 2022, in the year 2022. Yes, and it had given a direction to the High Court to dispose of as expeditiously as possible, my lords. The matter was parted before the coordinate bench, but they had released.
My lords, commercial appeal, appealing for the appellant, my lords. For the final hearing. This is the third time for moving on. Madam. My lord, miscellaneous first appeal of 22, there was a direction on the appellant to deposit a sum of rupees 60 lakh rupees. They've not deposited. We have filed an application for a direction, maybe posted on the. My lord, execution is filed, but we have undertaken not to precipitate with the execution proceedings.
Your Lordship, this is a matter of arbitration appeal, Your Lordship. The respondents have filed an execution petition for attachment of movables, Your Lordship.
MFA's lordship, I'm for the respondent to the matter.
The appellant in the matter, MFA, Your Lordship. MFA, Your Lordship.
If your lordship is inclined to list the matter, I'm placing a request to list on 7th, because prior to that, my
Appellant, Your Lordship. The matter is posted.
lordship, in any case, the executing court is not proceeding with the matter in view of the pendency of the MFAs before this court, despite there being no stay. So I would say there's no urgency in the matter. They could have moved the memo earlier. We have filed execution. Then your lordship may have it on the 7th of November. Your lordship may have it on the 7th of November.
Much obliged, Your Lordship. Yes.
Much obliged.
Now we can read back.
The fresh income tax appeal for admission. Any date convenient to my lord. Fresh appeal. 11th, my lords. 11th, please. Achha.
For
My
adjourn,
lords, seal number 36, my lords. Pray for an adjournment. Oh, sorry.
for adjournments, page number 5, 16 to 19.
Serial number 19, appearing for appellant. I will inform the other side also. Kindly have it on next week. Serial number 19, 19. Appearing for appellant manner. Kindly have it on next week. I will inform the other side also. Yes, madam. But some inconvenience. Yes, madam.
Then we will not give any date. That could be the difficulty. Who is the other side?
I am here, Lord. I have no difficulty.
My lords, in serial number 19, I have one request. I appear for the respondent, my lords. In serial number 19, there's a small mistake in the name for the counsel for the respondent, my lords. It needs to be shown as Manu, M-A-N-N-U, my lords, not Anu Prabhakar, my lords. Because of this, it's not been coming up on our list and we've missed the matter, my lords. I'm sorry, my lords, I'm unable to hear the court.
Let's wait. We just call the matter. Let's see. Yes.
Page number 6, 20 to 27.
My lord, serial number 24, my lord.
My lord, serial number 20.
24, my lord. Kindly have it on 25th of November. I'm for the respondent. my lord.
I'm for the appellant. They have informed me.
Informed.
The file your submissions in this.
Yes, ma'am. 25th, it may be listed, my lord.
Two 12.
My lordship. Serial number 20, my lordship. Serial number 20, lordship. I'm for respondent. Kindly, it may be urgent for 2 weeks as senior counsel has been hospitalized. My lordship, on Saturday, senior had an. Yes, my lord.
Then we will not hear. We will hear it. Yes, wait.
Page number 7.
Serial number 23, my lords. No, serial number 23, my lords. 23.
I appear for the respondent, Lord.
Request for 2 weeks, my lords. I've informed the other side, my lords.
I appear for the respondent.
She does, my lords. She appears for the respondent. my lords. There's a tax matter, my lords. Has. In 2 weeks, my lords. 23 minutes.
212.
Lord, serial number 20,
Sir,
25, my lord. You have taken up after 2 weeks, my lord.
Lords, serial
25, my lord. Please,
Just wait. We call the matter.
please.
Page number 7, 28 to 35.
35 minutes. 3 for 2 weeks, 10 minutes.
Prepare in the matter, my lord. Senior has been engaged. That's not a big deal. No,
Lords, my submission, my lords, this petition has become infructuous. Lords, what has happened on jurisdictional issue, my lords? They've raised one ground regarding validity of search. My lords, on merits, all the writ appeals, my lords, were withdrawn, income tax appeals were withdrawn on monetary limit. My lords, nothing survives in this petition as on today because they've already succeeded on merits.
no, but it's okay. Some cases, the case is pending before the.
My lords,
Supreme
that,
Court, this issue.
that case was withdrawn on monetary limit, my lord. Subsequently, there was an amendment to the section itself retrospectively. Please, my lord.
Prospective from
Please.
62.
Please, my lords, please. my lord.
Yeah, I think possibly Ramaiah Reddy has gone in appeal to Supreme Court.
That was withdrawn on monetary limit. On monetary limit, my lords, it was gone. It was not argued, my lords, because
In Chhattisgarh,
Please, my lords. Please, my lords. That
Appellant. Appellant.
my lords, that this mistake in the cause list, my lords, it is assessee's writ appeal. It is assessee's writ appeal.
Just wait. Let the matter be followed.
Please.
My lord, serial number 33, my lords. I'm appearing for the appellant in the case. My lords, we have engaged a senior counsel, Mr. Shankar, and there is some personal inconvenience for him. May I request the matter be taken up after 2 weeks, my lords? Serial number 33. My lords, we had engaged senior counsel, Mr. Shankar. He is unavailable to.
Yes, 66 of 2006.
Please, my lords.
9/12.
My lord.
Could also be a direction to file synopsis in the matter, my lords.
For the respondent in the case. You are a common counsel there.
My lords.
For parties to file the written submissions, they want to be judgment, they want to rely upon both the appeals, being STS 66 of 16 and ST RP 19 of 2015.
Much
Obliged.
obliged. Much.
Obliged.
Page number 8, serial number 36 to 42.
Serial number 39, my lord, I appear for the appellants in this, my lord. Kindly have the matter listed after 2 weeks, my lord. There's some inconvenience today. I have informed the other side also. Please.
Let's wait, let's see that.
Please. Seal number 36, my lords. Pray for an adjournment matter, my lords.
You appear for the other side.
Government advocate.
My lords, I appear, my lords.
16/12,
Grateful, my lords.
serial number 1. Shri Sanmati.
My lords, we have to produce a copy or annexure be legible, my lords. Some parts of it, my lords, are not legible. At the time of hearing, my lords will produce it. At the time of hearing, my lords, because we're on the impugn order. I'll file, my lords.
25/11. Serial number 2. Lata Shetty.
Appear for the appellant, my lord. I'm filing a memo, my lord. This was heard last on Friday, my lord. I may be permitted to withdraw with liberty.
Madam, one more minute. One more minute. All of the document.
Much obliged. Much obliged.
Serial number 3. Videsh Pandamit Dana.
Please, my lords, I appear for respondent number, appellant number 2, my lords.
I appear for respondent number, appellant number 1 in 3.3. Lord C.
No, my lords, there was a new panel which was formed for the DRI, DGJ and the CBIC. So in that respect, we have filed all the respective appellant number 2, I appear, my lords.
You appear for
One I appear.
for the same appellant.
Now it has
No,
been divided.
now it has been,
Earlier,
Like this. There would be go by the appeals, one appeal, you appear, one appeal, other. The appeal there would-
no, my lords, what has happened is,
we will.
we will
Sort it out.
sort it out, my lords. My lords.
My lord, 1083. Yes, my lord. I will take steps in those matters.
Request of nominations.
I'm for
Just
the
a
response,
petition.
my lord.
I don't know. No, my lords. Fair enough.
Is that also the issue to the respondent to the UA of 2021? Okay, we notify that. Returnable on the database.
I'm for the respondent, my lord. I'll,
6.
Which matter?
for item 3, my lord, I'm for the respondent.
You are which respondent?
Lordships, for both respondents, all the matters, lordships, for all the respondents, I'm appearing.
In all the matters.
All the matters, my lord.
In
Item
this
3.
1083 also.
Yes, my lord.
Okay.
I'll just confirm. Yes, my lord. 1083 also, my lord. 1083 also.
Because the notice was not effected, but you would
Yes,
appear.
I'll appear, my lord. I'm Hari Radhakrishnan, Lordship's counsel.
So you just say that, Mr. What is your good name?
Lordships, I'm Hari Radhakrishnan, advocate.
Mr. Hari Radhakrishnan, advocate, appears and states that he shall appear for all the respondents
Yes, my lord.
in this batch of appeals.
Yes, my lord. Yes.
Okay, the submission is taken on record. He shall also file his wakalat, if not already filed in these appeals for the respondents.
Yes, sir.
Okay, re-notify these appeals on.
912.
Directly obliged.
Much obliged.
Serial number 4. 3110.
Lords, I filed a memo for withdrawal of this petition, my lords. The reason is, my
Just
lord,
say this is an application, this is a memo for withdrawal of the appeal by the appellant. The counsel for the appellant retrades the pay for withdrawing the appeal. The appeal is dismissed as withdrawn. There was another matter need to be withdrawn. Okay.
Serial number 5. Sri Ravi Raghavan. 5.
Serial number 5. My lord, I pray for 2 weeks' time in this matter. For the reason, my lord, the Mr. Amit Deshpande has been relieved from this thing, and I have entered appearance.
Tell us one thing, what this is contempt, na, and the connector is the appeal.
Appeal, yes, my lord, it is so that
Yes, sure.
the writ petition was now challenged in writ appeal, my lord. They have filed contempt for, so for that reason.
Appear for whom?
I appear for writ appeal, in the writ appeal for the appellants, my lord. I
For
appear
the-
for the complainant, my lord.
In writ appeal.
Writ appeal.
That's for the revenue,
Yes, my lord.
for the foreign trade, DG foreign trade. Now, what remains in this, Mr. Shankar? Mr. Rashekar, what remains now? See there, if you see their stand and you have challenged this order which they have passed,
I
again represent the Union of India.
you appears for that.
Yes.
Complainant.
You have challenged it before the learned single judge?
Yes, my lord.
Everything must go.
My lords, after that, it was tagged along with the writ appeal, which we were not aware.
Even writ appeal is now infructuous.
Well, writ appeal is not infectious. We have challenged the single judge order
Again.
in writ appeal.
Now, contempt should go, my lords, in view of pendency of.
Where is contempt? Where is contempt? No, this is contempt.
My lords, there was an order, single judge order on 12/1/2022, my lords, against which we had filed a complaint. Later on, we got to know, my lords, that department is filing an appeal, writ appeal against that single judge order. Later on, when the matter was aware of, this matter was contempt was tagged along with the writ appeal.
Now come to see, even we are telling you also, the
Please.
revenue also, see
Please.
your affidavit which you have filed in contempt. See the affidavit. We will read it for you. On perusal of the contempt petition, it is noticed that Office of Respondent number 4 has already issued amendment on 2, stating that it is in compliance with the order of this court on 12/1/22. What does that mean?
My lord, first of all, my lord, my apologies. The only thing is that I don't have the affidavit as on today.
My lords, that affidavit is filed by me, my lords.
You
That
filed it.
Yes, it's in the contempt
Oh.
proceedings, I have filed it.
Now, what is the stand which has been taken in that affidavit?
Yes.
Now, if you see the order, para 15 of the order of the learned single judge.
Yes.
In the light of the facts as made out above,
while noticing that mistake that has happened in it is a technical mistake and is bona fide. On such technicalities, to deny substantive relief to the petitioner would amount to denial of justice. Accordingly, the court set aside the impugned decision of the PRC dated so and so, as well as the reviewed order dated so and so passed by the respondent number 1. Respondent number 1 to allow the benefit under MEIS to the petitioner in respect of 17 shipping bills, which is the subject matter of the present petition as detailed at page 105. Necessary formalities to facilitate extension of benefit under the MEIS to be made.
If you see in the light of this direction,
Affidavit, my lords, para 11.
para
11.
Para 11, now you have said that in compliance, you have issued the amendment.
Yes.
And you say that in compliance with 12-1-22.
22. That is this order.
So that is this learner single judge order.
Yes.
Will that mean
virtually, my lords,
direction has been given, has been complied with?
It is not complied, my lords. It is in the process of compliance.
Very good. We don't know. At least once you, now what you say is also now see 12.
Para 12 lords.
The office of the respondent submits the answer claims the process on the basis of the amendment issued by and the process of granting benefit to the is pending only because of the sole reason the respondent number 4 has informed the office of respondent number 1 that the decision on the scope is under challenge.
Yes.
So
virtually writ appeal, my lords.
Infructuous, possibly you have to withdraw appeal if the appeal, because your stand is this, because the appeal is pending.
Appeal is pending.
And we are not taking any further action. Getting the point, Mr. Ashish?
Yes, yes, my lords.
So once the appeal is withdrawn, you will implement it in terms of amendment.
That is up to the.
Don't know, but see, we don't know. You appear for the same respondent, he appear for the same.
I appear for the Principal Commissioner of Customs.
He appears for customs, I appear for respondent number 1.
But all are appellants?
Yes. Yes.
All are appellants?
The appellants are, my lords, respondent number 4, 3 and 4.
Let's see who are the appellants. See, everyone is an appellant here. Except possibly even Principal Commissioner of Customs is an appellant. So all who have filed the affidavit in contempt and even the appeal, they have to only sit together and work it out.
Yes. May I make this request, my lords, sir? May I make this request, my lords, sir? This matter may be taken up after 2 weeks.
We'll have it after 2 weeks.
2 weeks, my lords. In the meanwhile, my lords, I'll ask the
At the
officer.
request of counsel appearing for the respondents in CCC number 923 and 2022, and also the counsel appearing for the appellants in WA 525 2022. Seeks an adjournment by 2 weeks to take instructions.
Yes.
At their request, we notify. Obligement.
1111,
Great.
serial number 6, Shri Dilip.
Serial number 6, I require 2 weeks time, Lord, for filing better affidavit, my lord. So there is a delay of 293 days request.
How much is the delay?
293 days, my lord.
293. At the request of counsel for the appellant to file a additional affidavit in support of IA 1 of 2023, re-notify on. Ma'am, you want to file any objections?
My lords, may I have may I examine the application and then?
Just say that is granted 2 weeks time to file additional affidavit in support of IA 1 of 2023. Liberty is with the counsel for the respondent to file a response to the IA 1 of 23 within 2 weeks thereafter.
Great.
212, serial number 7, Shri Dilip.
My lords, weeks time, my lords, to take fresh
Let
steps.
fresh notice be issued for service on. Ma'am, is there any report, ma'am?
No, sir, first time.
Let fresh notice be issued to the respondents returnable on.
My lords, I'll take fresh steps, my lords. In addition to that, my lords, I may be permitted to serve on the advocate who's appeared in the writ petition, my lords. It will same counsel.
We can say, but you must serve the
My
respondent.
lords, in addition to that.
Additionally, the liberty is granted to the counsel for the appellant to serve the counsel who appeared for the respondent before ITAT.
My lords, before the learned single judge.
For the learned single judge.
Published.
6/1/2025.
Published.
Serial number 8. Shizan.
You'll also file an additional affidavit. I've seen that. Same order, ma'am. CXN is allowed 2 weeks to file reply, additional affidavit in support of IA 1/24. Liberty is with the counsel for the respondent to file a response to the IA 1/24 after 2 weeks of the filing of the affidavit.
2/12. Serial number 9. Shisamati.
My lords, in serial number 9, I seek 1 week's accommodation, my lords. Could it be
Do
taken
you
up?
have any serious issue on the additional?
My lords, if my lords recollect, this is the matter that had come up last week, and Mr. Suryanarayan, our senior advocate, was ready in this matter. At that time, the revenue submitted that they want to raise an additional question. My lords, on this question also, our point is that there are decisions today covering this question in my favor, my lords. I don't see any merit.
What about the other questions?
My lords, the other questions are also settled by this honorable court's decision itself in my favor. My lords, this in
This
the
one-
SSC's own case.
The counsel for the parties to file their written submissions along with the judgment they want to rely upon. Just before that, say that a memo for framing additional issue, additional substantial question of law has been filed by the learned counsel for the appellant. First of though the learned counsel for the respondent seeks some time, seeks an adjournment, appropriate shall be the counsel for the parties to file written submissions.
2/12.
Be taken up on 4/11, my lords, next week.
4th
4th November, my lords.
Not possible, ma'am. You see it there. Next.
2/12. Serial number 10.
I appear for the appellant. Because I sought withdrawal of the appeal.
This is a memo for withdrawal of the appeal by the learned counsel for the appellant. The memo reads as, and I just give the file. Is it here? See, no need. This memo is here now. Which reads as under, the learned counsel for the appellant reiterates the prayer for withdrawing the appeal. Appeal is dismissed as withdrawn.
Most grateful.
Serial number 11. Sumalesh. 11.
My lords, I appear for the respondent, my lords, in this matter. Upon submission, the impugned order, my lords, disposed of 2 writ petitions, my lords. There is also a connected writ appeal, that is writ appeal number 669 of 2024, where a coordinate bench of this honorable court, my lord, directed that this appeal be tagged with that appeal, my lords. That I think has been missed out by the registry, my lords.
That is of which year?
My lords, 669 of 2024 itself, my lords.
May I submit here?
This would come here. No?
Same, different assessees, same matter.
The flags are it.
Question of law is same.
Question of
Please,
law is
my
same. Already the notice has been ordered. In this case, I have served the other counsel already. A formal order has to be passed saying that the notice is served already on the other counsel. And they also filed wakalat.
Please, my lords.
Since he is appearing, you have served him.
Yeah, already served it before the order is passed. Because
My lords,
the other case have already been ordered.
There is some legible.
My lords, the
Annexure J.
that is Annexure J is just a formal document which we got it from them in the writ petition. Same thing we have improved upon.
You get it typed and file it.
Lords, in the other set that this objection is not there and the same documents are there. Kindly
Just say this, so and so appears for the respondents, and as such, there is no issue on there is no issue on notice.
My lords,
Yes,
I may be permitted to explain, my lords. In appeal number 669 of 2024, my lords, notice was issued. I accepted notice, and because this is a connected matter, the impugned order was a common order disposing of both
The
matters.
respondent is common there?
My lords, the
No,
respondent is not
husband and wife.
common, but it was a common order, my lords.
Yes.
husband and wife.
Yeah, we got it. We have been informed by the counsel. You appear for the respondent and you appear for the appellant there?
Yes.
That's right.
We have been informed by the counsel for the parties that a connected appeal arising from the same impugned order.
Impugned order, my lords, please.
Just 1 minute. Let's be clear on this.
My lords, it is this impugned order, my lords, is dated.
Common order.
Impugned common order dated 12/12/2024, my
Impugned
lords.
common order. Impugned common order dated
12/12/2024.
Be also listed along with this appeal. To stop. They inform us that there is no date of hearing in that appeal. Are we right?
There is no, that's right, my lords.
Any date of appeal, date of hearing?
No, no.
If that be so, this appeal shall be tagged along with that.
Yes.
Please, my
Yes.
lords.
There is an order.
There is no such order.
My lords, there is an order in 669 of 2024. If my lords may permit, I'll project that order if possible.
We have also been informed by the learner counsel for the respondent. There is an order in the, what is the writ appeal number?
Writ appeal number, my lords, 669 of 2024, my lords.
There is already an order in writ appeal number 669 of 2024. Full stop.
The order is dated 9/9/2024, my lords.
9/9/2024. If that be so, let this writ appeal be listed along with writ appeal number 699.
669, my lords.
669 of 2024. Full stop. Insofar as the objection of the registry on the illegibility of annexure J is concerned, and the counsel for the appellant states that he has filed the same annexure in the connected appeal 699 of 2024, and there is no such objection on the illegibility of the said annexure. If that be so, the objection with regard to annexure J in this appeal, that is WA 649 of 2024, is overruled. Okay, just give a date.
My lords, in the meantime, I may be permitted to file my counters, my lords.
No, counsel for the parties to file the written submissions along with the judgment they want to rely upon.
Please.
You file it in the other also, in this also.
I will do that, my lords.
The record is complete. Whatever the record before the ITAT, before the
single judge, my lords.
ITAT, this is a single.
Right. Has been filed here.
This is arising out of writ petition.
Right. We are saying whatever record there has been filed here.
Yes, yes.
Okay. Then file your submissions.
Please, my lords.
Sir,
What's
9/12.
most likely AAG will be appearing in this.
Whosoever appears.
Yes.
My lords, may I request for 13th of December, my lords?
See, we give Monday.
Please, 16th, my lords, 16th.
Have it next Sunday. Have it next Monday then.
1/6, my lords.
16 December.
Please, my lords.
Serial number 12.
I'm grateful, my lords.
Number 6 in
I
this
appeal for the
matter.
petitioner, my lord. I have served the copy on the BBMP, my lord.
That's I appear for respondent number 4 minutes.
Respondent number 4 is the BBMP. I
We
served
give
the
short
cop-
accommodation.
Who has to file counter affidavit in all? In this?
My lords, I have
All the
to file
respondents,
a
sir.
counter, but before that, my lords, there are serious objections on maintainability insofar as locus and also previous orders of this honorable court on the same cause of action by the same
Ma'am,
petitioner.
you will put it in black and white so that he.
Very well, very
Please,
well. The orders are in fact produced.
Locus, anything, put it in.
Very well, I
file.
will.
Now, you appear for whom, ma'am?
For respondent number 6.
You appear for respondent number 6.
Respondent number 4, I have served, my lord. They are entering appearance, my lord.
That's I appear for
Yes,
respondent number 4.
Now, who appear 1 and 2?
I'll appear for 1.
You appear for 1 and 2. Who appears for 3? BDA.
They have not filed wakalat, my lord. They have not filed entered appearance.
But have they
Despite
been
service,
served?
please, my lord, serve it, my lord.
3 has been served. Then what about 4?
4, they are in.
I appear for respondent number 4. I undertake to file wakalat.
5, who appears for 5?
He also supposed to be BBMP only, my lord, because it's the BMP of BBMP.
This comes under BDA.
Please, BBMP, my lord, BBMP.
BBA.
Respondent number 4, my lord.
You appear.
Yes, my lords.
And 6, you appear.
Please.
Just say that councils, the respondents are represented by the councils. Will stop the learner. Now you have filed your counter 1 and 2.
No, my lord,
There are no
nobody.
directions against me, my lords. I'll support the respondents, my lords. I've not filed, but there are no
Counter
directions.
affidavit, let counter affidavit be filed. Counter affidavits be filed by the respondents within 4 weeks. joinder within 2 weeks thereafter. Re-notify the petition on.
My lords, may I make one request? My lord, since the BDA is the answering respondent, may I also request your lordships to permit the petitioner to serve it on any standing counsel?
No, it's already served. And additionally, I'll serve it.
On a standing counsel.
Already
my
it is
lords,
served.
Just say that we find there is no appearance for the respondent number 3 despite service. Let liberty is granted to the counsel for the petitioner to serve an advance copy of the petition on the standing counsel for the respondent number 3.
So I will serve it on B. Vachan, my lord, because he is the one who was appeared earlier also. BDA counsel.
We can't every time.
Please, please, I will.
Let it be, just say this, just cut the last sentence. Then a counsel for the petitioner states that he has also served an advance copy of the writ petition on Mr.
B. Vachan, B. Vachan.
Bachchan, the standing counsel for the respondent number 3.
Please.
Very well.
1911,
I'm great.
seal number 13, Shri Sanmati.
Plus issue of transfer pricing, my lords, there's a delay of 119
My lords,
days.
Before that, my lords, may I just request my lords to direct deletion of my name from the wakalat, my lords. I'm instructed not to appear in this matter, and I'm told that another advocate is instructed to appear.
Just say that Ms. So-and-so states that as the respondents have engaged another counsel, her name be deleted. But you must ensure.
Yes, my lords, I have already
She
informed.
said that she shall ensure the appearance of the advocate on behalf of the respondents on the next date of hearing. So now this will also await those that.
Yes, my lords.
When a counsel for the appellant states that the matter, the appeal be adjourned in due course to await the decision.
But if I request for delay to be condoned, my lords,
On that
matter be posted for admission.
1 month. Let the counsel be there.
Yes, my lords.
Where she is not now. Be adjourned be adjourned to be listed in due course to await the decision of the coordinate bench, which is hearing the identical issue.
Yes, my lords.
In a remand matter by the Supreme Court. So accordingly, list in due course.
14, Rajesh Kumar.
My lord, appearing for the appellant in this case.
For the respondent.
My lords, on 19/9/2024, my lords, the respondent's IA came to be allowed, whereby they have, this honorable court had permitted the respondent to withdraw the amount that we had deposited. My lords, I objected to that application on the ground that they can withdraw, but they should provide a security. My lords, my objection wasn't taken on record, and hence I had filed this IA for modification of the order. So, as per order dated 10/9/2024.
The amount is still lying in the registry?
Yes, my lord.
Please, my lords.
It's a dispute between a landlord and tenant. I'm the landlord. The decretal amount is about 4.5 crores. The amount in deposit before this court is only 50 lakhs. Considering this and the judgment of the apex court, the learned judges felt that 50 lakhs could be given to me. And they did make a mention regarding the security that requires to be offered. They did make it. Then the learned judge cited the judgment of the apex court and said that I can receive this 50 lakhs from the court without offering any security. The total amount due in terms of decrease 4.5 crores with interest, which will almost come to about 5.25 crores now. And the amount in deposit is only 50 lakhs. It's a landlord and tenant dispute.
Then what, you see, let's see which order you are referring to.
Order dated 19/9/24.
Was the submission recorded?
Yes, madam.
Their submission
Yes,
on security?
they have filed that in the objections as well. They have very specifically stated so in their objections.
My lords, I'm only requesting that they can withdraw the amount, but they may be directed to provide a certain security while waiting.
Ma'am, I think that's what we being contended, that such a submit. But tell us, Mr. Ravi Shankar, tell us what is the difficulty in giving a security?
No, the learned judges felt that if
Which order says so?
19/9 is the order this court passed. Page 3 of that order, madam. Page 2, para 2. Learned judges also took note of my lord Justice Rachia was their part of it. That's the para 2. Learned counsel for the appellants had filed detailed objections to the application seeking for release of the amount. Same mistake. Appeal has been preferred so on. So next page, madam. In this regard, relevant to refer to an order.
Just one. Why should we relook into this order once there is an order?
The maintainability is the one.
We can't review this order, no? You're right. Now, have you filed any application?
I have filed an IA for
modification.
That which is why it is listed today.
Where is that plea with security need to be allowed to be withdrawn?
That is there in the objections to my application. That is there in para.
Your objection.
Para 10, page 3 to IA3 application. They have filed. The learned judges took note of this.
But where is the noting? Where did the court noted this plea?
This plea is not reiterated in the course of the order, but they did note the objections that is filed. Para 10, line 3. Para 10, line 3.
Your objection.
To their objections to my application. IA3 bar 24, my application. They filed objection. Para 10, line 3. They did say that
Who is the landlord?
I am the landlord.
You are you are the tenant. There is an admitted liability also?
Yes, my lord.
On your part, is there any admitted liability?
You have to check that.
See, admitted, the farthest or the highest amount which need to be paid is 4 crores on. You say 50 lakhs. If 50 lakhs is admitted liability,
Please.
then I don't think anything. It's purely inconsequential. This security, because in any case that amount you have to pay.
That's the same analogy that's this honorable court felt.
I'll leave it to Manoj.
Getting the point?
I'll leave it to Manoj.
Just shows that. We will see if the objection says so and that order.
I may be permitted to read so that.
We'll just see that.
Para 10, page 3.
Ma'am, our reply is not there.
They filed this in the court itself.
According to you, is payable.
Manoj, senior would be submitting on that.
If your case is 50 lakhs, only 50 lakhs is payable, it doesn't make any difference. Getting the point? Doesn't make any difference, security, no security, because that's in any case is a liability which is admitted.
Para 10, my lord, if my.
Do they in their appeal says how much is the liability?
I made a statement in my application.
Not yours, their statement.
They don't say. Para 10
In my objections.
and line 3. This is page 3 of that objections. Page 3.
Objections dated 19/9/2024, Manoj.
I mean, it is submitted that notwithstanding the foregoing, in the light of the deposit being made without prejudice and without exceeding to the liability under the impugned judgment in the.
Shankar, just one. You know what? Why did you say this? If the court was to order 4 crores, there should be security. Will your objection still hold good when it is 50 lakhs? Getting the point? Take instructions. If ultimately why are you pressing this? You may be right. If it was 4 crores, maybe liability is 1 lakh, 1 crore or 50 lakh. Security need to be given. Just take instructions on this.
Need date next week?
Pardon?
Need date next week, Manoj, Monday?
We'll give you, but you file your submissions on the.
I have filed objections to this
You have filed,
application.
no, that will suffice.
No, I am requesting my lord to fix a date for final
We will.
disposal
Counsel for the
because the
party.
matter lies on a very narrow compass. It's a landlord, the relationships are admitted. Delivery of possession is also made by virtue of the.
We will only for this purpose, we will have it to say a short date. For final hearing, we'll have it at a later date. Let's say, let her take instructions on the security, keeping in view the order passed by this court on the last date of hearing. At the request of counsel for the appellant, to take instruction, re-notify.
For 11. Number 15.
Serial number 15, I appear for the appellant's counsel. There is a fairly significant delay of about 278 days. But on merits, I think we have an excellent case where, just in a nutshell, what has happened is initially the assessing officer had denied us certain deductions on one or two grounds. We filed an appeal. The CIT appeals allowed our appeals. The income tax tribunal affirmed the CIT appeals order. Now, as the revenue approached this honorable court said the ITAT order, quote unquote, is rather cryptic. Therefore, you cannot merely rely on a previous order. Please give reasons. Now, what the ITAT then did was remand the matter back to the assessing officer. Now, once we were aggrieved by that, we approached this honorable court saying that ITAT could not have remanded when there was an express direction for them to decide. This honorable court set aside the ITAT order and said, when there's an express direction of the High Court, you should have decided it. Now, that's remarkably what the ITAT has done once again is remanded the matter back to the assessing officer, which is why, my lords, we are forced to once again file an appeal. All factual issues, my lords, we have presented. In fact,
why don't you go back to the ITAT?
No, my lords, kindly see what the, can I just point out certain orders of this honorable court, my lords? Now, if my lords were to see the original order of remand by this honorable court, which my lords will find at page 133. Paragraph 8, my lords, in the backdrop of the aforesaid factual position, when we advert to the facts of the case,
Pyramidal projects.
That's right, my lords, on pyramidal projects, so on. So therefore, the matter is remanded. Then, my lords, after the matter is remanded, as I mentioned, the ITAT once again remanded. Now, kindly see how the this honorable court deals with the matter, page 81 at paragraph 8 once again. So after it is well settled law that when the direction is issued by the jurisdictional high court, the tribunal is expected to comply with the same in letter and spirit, even assuming that no factual finding is recorded either by the assessing officer or the CIT appeals. That exercise ought to have been done by the tribunal as the final fact-finding authority, which has coextensive power with that of the AO and the CIT appeals. Accordingly, remanding the matter to the assessing officer is not the solution to the litigation, which would open up a third round of litigation, making the assessee to suffer, and the same is nothing but harassment to both the parties, unnecessarily delaying the entire process of adjudication. Hence, without answering the question, the matter is remanded back. Now, my lords, may kindly see that portion of the impugned order.
See your grounds.
Yes, my lord.
See your grounds, except one ground, possibly one ground.
Yes, my lord.
Rest are on merits.
On the merits, yes, my lord. Now, of course, why we chose to do that?
Effectively, you want that we should take over.
Not that much. That is only the matter of abundant caution. If my lords were to deem it appropriate to decide, we are in your lordship's hands. But ideally, yes, I admit the matter should be sent back once again to the tribunal for them to decide the matter once and for all. Rather than what will happen, my lords, is we have to go back to the assessing officer. We are not shy of going there. But when this honorable court has said that is not appropriate, the question is whether it was appropriate for the tribunal to once again remand the matter. And all the facts were there, my lords. If my lords were to see the impugned order, I'll take my lords through it. All the facts were provided. The issues were only two: whether there were 4 units or more in the software park constructed by me. That is not rocket science. I've provided the details. 2.
No, mind it.
Yes, my lord.
On 2 points,
yes,
it accepts. 2.
Correct. On electricity bill and water bill. My lords, they could have asked us to produce. We're ready to produce. We'll go back to the tribunal and produce. And if your lordship deems it, we'll produce it before your lordship.
See, we'll tell you.
Yes.
Possibly you will be able to satisfy on those 2 points. It's only now narrowed down to 2 points.
Yes, we should be able to.
They don't agree with you.
Correct.
We will have also an additional, reasoning. For what reason those have been.
No, of course, madam. The only question is now, would it be a question I asked myself, would it be necessary to once again go back? When really, as your lordship rightly pointed out, there were 2 small issues. They could have asked us.
Let the authorities who have to apply their mind first. Then we will see.
The problem is, Malad, this has been going on back and forth since.
Right.
That's the only issue, Malad. If my lord,
we agree with you.
That's the only issue, really. Which is why, Malad, although we have raised extensive grounds on merits, I'll frankly admit it probably is not within my domain to raise all those grounds before this honorable court. But the tribunal could have put me on notice, said, please give me these. If I was able to satisfy them, there ends the matter. So that's all, Manoj.
Now, suppose for a moment now, ITAT is effectively a second appellate.
Correct. It's the final fact-finding authority. That's right. Second appeal.
So then you will have the benefit of the first appellate authority also.
Benefit.
And then IT-80, then here on a
Correct.
substantial question of law.
That's
I don't think that really would come.
Benefit is one way of looking at it rather than, I mean, the way we look at it, Malas, we're put through the rigors of it all over again. So it's which way one looks at it.
We should now look into it.
No,
So then
let
we are
the- let-
reconsidering everything, overlooking, there are three authorities.
No,
who
the
can-
only
who
thing,
can.
if the matter is sent back to the tribunal to determine this issue itself, rather than sending us back, only to that limited extent. Only to that limited extent. Now whether I am eligible under 80 IA or not, possibly, because it's a fact-finding mission.
That would also be on the same analogy when we are not, we are
Correct.
refusing, IT-80 would also be better, would be, you have two authorities.
Yes.
Let them apply their mind.
Then, my lords, could your lordships consider having this matter maybe in 2 weeks? Because there is also a pleading, I don't know whether my lords noticed, where the assessee also contemplated filing either a review or a miscellaneous application before the IT-80. Could I get instructions on that?
The
my lords?
jurisdiction is there with the.
Yes, but it's there, it's there. So could I come back with those instructions? And if that is the appropriate, if that's the path the assessee chooses, then I can withdraw this appeal.
Just say that at the request of the then a senior counsel appearing for the appellant, re-notify, just 7th, 8th, 9th, any day. 8th, 9th, 10th, any day, not 4th. Say November 7th.
7th.
No, I'm sorry, 11th.
Grateful.
11th.
11th.
Obliged.
Number 16, disseminate.
My lords, 16, 17, 18, my lords, are all Supreme Court remand back matters, my lords. Matters may be kept by my lords.
These are all this thing, no? Transfer pricing.
Transfer pricing.
16, 17,
18.
18. Ma'am, you are the counsel there in
Yes,
all the
Manas,
matters?
in all three matters.
Just say that Learner Counsel for the party states since the issue which arises for consideration is in respect of transfer pricing. And then as a coordinate bench of this court is considering the identical issue in a remand matter by the Supreme Court, these appeals be adjourned, be listed in due course. It's ordered accordingly.
19, P.D. Surana.
Lord 3922, I am for the respondent.
I'm the respondent, my lord, in item number 19. I'm seeking some time. There was some difficulty, my lord, because the cause list showed the wrong name. Instead of, my lord, Manu Prabhakar, it was showing Anu Prabhakar. Therefore, my lord, I had some difficulty. I couldn't appear on the last 2 dates. I'm just seeking a short date, my lord. Even if my lord will have it next week, I'll file written submissions. Matter has not yet been admitted.
Issue is identical in both the matters.
No. I have no instructions in the first matter. The
Who appears in first?
I appear, my lord.
for the respondent,
For the
she's in,
respondent.
yes.
No, who appears for the appellant?
Mr. Surana appears. They tried mentioning at 10:30.
Just pass over, let them come. We'll just pass over.
Lordship, or Lordship may consider this is a 37 pleadings are completed. Anyways, it requires some time. Would Lordship consider another date, Lordship? Then
We'll let him come.
Lordship.
Let him come. 20.
Serial number 20, Sri Hanumanta Reddy.
My lordship, I'm for respondent.
Appear for the appellant.
Yes.
My lordship, my senior has been hospitalized on Saturday. He had an cardiac arrest, my lordship.
Just say that at the request of counsel for the respondents, re-notify. When do you want, ma'am?
After 2 weeks, my lord.
After 2 weeks.
Obliged.
20th November.
Grateful.
Serial number 21. Sri Sanmati, 21.
My lords, in 21, would my lords consider giving me 4 weeks adjournment? My lords, in this matter, the SSC is considering settling the matter under the amnesty scheme, which is now promulgated.
We won't come in the waivers. But there's a delay of 68 days, my lords.
On that basis, we can dispose of this appeal.
My lords, not yet, because we've not yet filed our application, my lords. Could some time be given until I file my application?
No, but you tell us how much time you will file.
My lords, 4 weeks.
And you will consider that?
We'll consider, my lords. It's an amnesty scheme, my lords. It's a scheme open for everyone.
No, can pending this consideration, can we say so disposed of?
Yes, my lords.
Or can we say so that
My lords, my only
any
difficulty.
cause survive, you can revive it?
Could my lords consider keeping it back by another 2 weeks, my lords? By then I will just get some clarity. my lords.
Learned counsel for the respondent states she has instructions to submit that the respondent intends to file a what is that?
Declaration under the Vivad Se Vishwas scheme, my lords.
Declaration under Vivad Se
Vishwas.
scheme, na?
Yes, my lords.
Scheme floated by the appellant revenue. Appellant revenue. When do you want?
Could my lords consider adjourning it by 2 weeks, my lords?
No, you will get instructions or you will file it.
My lords, I am told that the SSC is considering filing the application, my lords. We have some time. We have time until December to file the application, my lords. Therefore,
So you will have some concrete instructions so that possibly we can put it and possibly we can dispose it of.
if that is the situation, my lords, would my lords consider adjourning it by 3 weeks, my lords? I will get some
Tell us one
instructions.
thing, suppose for a moment you reject their request or you don't fall within those schemes. What would be the effect on the appeal?
Appeal will have to go on merits, my lords.
We'll have to go on merits. Just see after 3 or 4 weeks.
212. Serial number 22. Shri Sanmati. 22.
This is also transfer pricing.
Transfer pricing.
We'll have the same order.
My lords, matter may be admitted, my lords, because what will happen, my lords, these are all not the remand matters, my lords. These are all fresh matters.
These are demand matter, no?
This is not a remand matter, my lords.
This is not. What
This
about
is
the
not.
other one?
Other one
previous-
also remand matter, my lords. Those are matters which came back, my lords.
Okay. Just say this, admit.
My lords, on admission, may I just make one submission? Question number 1, there are a number of comparables mentioned in that question, my lords, but not all of them arise for consideration. My lords, really, if my lords notice in the question, from the
Yes, there are
7th line,
many
my lords,
L&T, all those things.
my lords, from the 7th line, Sagar Soft onwards until ACE BPO,
Mhm.
these companies were only remanded for consideration, my lords. They were not excluded by the tribunal. Today, the question reads whether the tribunal was right in excluding these companies. That may not be right, my lords.
What do you say? They have been excluded? For what purpose?
My lords, they have not. So, my lords, before the tribunal, I had raised grounds. I was the appellant before the tribunal, and I had raised grounds challenging the selection of certain companies by the TPO. Now, some of the companies were directed to be excluded from the final list of comparables, while some were remanded to the TPO for verification to determine whether they were to be excluded or not. Now, the questions raised, my lord, not all of them were directed to be excluded
So-
by the tribunal.
So far as exclusion is concerned, there cannot be any grievance.
Insofar as the remand to the TPO is concerned, their question cannot be, there cannot be any grievance, my lord. It's definitely not a grievance that they were directed to be excluded. Therefore,
That cannot be a grievance.
yes, my lords.
But for the remand, possibly there can be a challenge.
My lords, remand, really, it will depend on the outcome of the remand. Today, there is no grievance to the department.
But you can argue that what prejudice has been caused from.
Yes, my lords, there is no prejudice today. Therefore,
What do you
So the
say?
question of comparables, my lords, is an issue we have to argue in law, my lords, to whether to include or to exclude, my lords. So, my lord, all this can be at the time of hearing, my lords.
Let's see if there is ME, okay.
Purpose, my lords.
Just admit the following substantial question of law. Questions of law arises for consideration in this appeal. The stop as a coordinate bench is deciding an identical issue of transfer pricing, comma, to await the said judgment, comma, list this appeal in due course.
Great. 23, 24 urgent, 25, Shannamalai, 25.
See, 25, we just wanted to know why this appeal?
My lord, this
Huh?
is 148 challenge, my lord, and order disposal of objection was challenged, my lord. It was quashed by the learned single judge.
It's only
my lord.
academic, my lord, no. Only academic.
So far as that,
Possibly, it would be on an opinion or on an assessment, reassessment. It appears.
yes, my lord, it is against 148, my lord.
My lordship may kindly see, my lord, page number 39. It starts from, my lord, para 15, page 38, the finding.
Tell us one
You know,
thing,
learn
you have
some-
not challenged.
The revenue challenge.
Revenue has challenged it.
Where is it?
That's in, writ appeal number
The-
960.
So then we will have it along with that. We are under the impression only this appeal and said.
But
why this
nothing,
appeal?
there are no proceedings against the petition by the, against the present appellant. No proceedings at all. 148 is set aside.
148 is set
Set
aside.
aside. We are aggrieved.
But tell us one thing.
Please.
What is the effect of this order? See, what does it say? Para 16, 6, 5th line. It would be a case of change in opinion.
Please.
Hmm? And in that even reassessment would be impermissible. Your case may be, it may be a case of reassessment.
Please.
That's why in the appeal. So even assuming for a moment this is a change in opinion, what is the consequence of change of opinion?
Change of opinion, my lord, 148 cannot be issued. Once
Achha, it
on a,
cannot be issued.
once on a particular issue, if the assessing authority has, my lord, deliberated on it.
Then why did you file this appeal?
My lord, I
They-
argued the first ground, my lord, 147, the first proviso to 147 clearly indicates, my lord, that after 4 years, if there is an original assessment order is passed on to 143.3, my lord. After 4 years, this reopen has been done, my lord. There is a condition precedent for initiating the proceedings under 148, my lord. There, unless there is an allegation in the reasons recorded.
Right, but you are, in a way, this stand has been accepted, no?
My lord, so far as that ground is concerned, it's held against me, my lord. To that extent, I have preferred and.
Where is that? Where is that?
Please see, my lord.
Probably
Please
page
see-
33.
Please see
para
page
10.
number
33 para 10.
32, my lord. And para 33, page 33, para 10. 10 is the finding, my lord. It starts, that issue starts, my lord, at page number 30, para 6 onwards, my lord. Regarding the 147, the first proviso, my lord, it starts at page number 30 from para 6, my lord. 6, 7, 8, after 8, 9, my lord. Then para 10 is the finding, my lord, at page 33, my lord. To this extent, I am before this honorable court, my lord. To this extent of the finding, because this is covered by this honorable high court decision, various number of decisions are there, my lord.
Your appeal list?
Date is not given, my lord.
This is an office
That is not
objection, sir. My lord,
My lord,
this
there is a
issue is
delay in
squarely
file-
covered,
I'm told
covered
that-
by various decision of this honorable court, my lord.
Just say that re-notify this appeal on. Just simply re-notify. Get it your appeal along with that.
Please.
On that date when we are giving.
My lord, there are no objections, my lord. We have to file a application for condoning the delay.
You file it, get it listed on that day when we are fixing this appeal.
9-1. Number 26. Philip.
For the
You are
respondent.
ready?
Delay may be condoned, my lords. In this matter, learned senior counsel, Mr. A. Shankar is briefed in the matter. Today has some, can be taken up on 11th, my lord?
There is a delay of 192 days. You have any objection?
No, maybe condoned.
26, just say this is an application seeking condonation of delay of 192 days in filing the appeal for the reasons stated in the affidavit. And the learned counsel for the respondents have no serious objection, comma, the delay of 192 days in filing the appeal is condoned. Okay. The application is disposed of. List the counsel for the parties to file the written submissions. Along with the judgment they want to rely upon, list the appeal on.
11-11.
Obliged.
27, Shridesh Pandey. 27. Serial number 27. Shridesh
Appearing for the
Pandey.
rest.
Just say pass over.
Twenty-eight.
Your Lordship, I appear for the respondents. Serial number 28, Your Lordship.
Yes,
Your Lordship, the matter may be kindly passed over. The senior is on the leg in the other court.
pass over.
Much
Why
obliged.
did we,
That's to ascertain if there are similar cases that's been filed. That's as per the information given by the commissionerate, concerned commissionerate, they're not aware of any such orders being taken up, my lords, similar orders being taken up, and similar orders being passed by the commissionerate either, my lords.
29?
29. To Sanmati.
These are all transfer pricing.
Yes, my lord, this is a transfer pricing.
So will that have a bearing here, the matter under consideration?
On some questions, I think it may have a bearing, my lord.
What do you? Shall we await that?
Whatever is convenient.
Because it is posted for further hearing, my lord. It is likely to be concluded because it will have a bearing on.
Yeah, let's just say 30, 31 and 32 also,
32 also.
34 also.
34 also.
30. Just say that these appeals pertains to transfer pricing as an identical issue is being considered by a coordinate bench of this court in a remand appeals by the Supreme Court, comma, to await the outcome of the said appeal, comma, list this appeal in due course. What about 37?
37, yeah.
37 is how I believe.
No, my lord, that's not a transfer.
That's not.
Your Lordship, 44 is also same.
44 is same,
Yes, my lord. But this is 2023, my lord. Let it come in
and
that.
you appear in 44.
I
no?
appear in 44 minutes.
This is also same.
This is transfer pricing, but not remanded by the Supreme Court.
Let it come in the due course. my lord. Answer.
Not remanded.
This
Not
is not
remanded.
remanded by the Supreme Court, but transfer pricing matter.
So we have two sets. One, those remanded, those are transfer pricing,
matter.
not remanded.
Yes.
44 also say.
Thirty-five. Serial number 35, Dilip.
30,
35.
35 we adjourn now. This is, we have 35 we have not. Okay.
Serial number 35, Dilip.
My lord, this matter may be taken up after a week's time, my lord.
Page number 38 is the finding.
So what shall we do in this?
My lord, it can be disposed, my lord, because what happened was originally,
Now, this issue has not been decided by the Supreme Court on 132.
No, my lord.
132, my lord,
See, the issue is only
Chatti,
132.
my lord, Trilox in Thilan's case, my lord. Chhattisgarh High Court decided the issue in the favor of the revenue. Then, my lord, SLP came to be dismissed.
That
Now,
explanation-
as on, and my lord,
My lord, that explanation to 132 has been challenged before the single judge, my lord. The matters are pending, my lord. And not in respect of this assessing, my lord.
But what would be the
Respect of-
effect of this judgment on that?
so far
single-
as this, my lord, writ petition appeal is concerned, my lord, this issue was never raised before the learned single judge. That's what, my lord,
No, but
in
here,
page number 38,
the learned single judge had considered this issue.
he says, my lord, it is never, my lord, separate writ petition is already pending. However, no such challenge to the amendment has been made in the present writ petition. That is a finding, my lord, page 38. First para, last 3 lines, my lord.
Who has challenged the virus of this amendment?
Amendment challenged by various other assessees, my lord, not by this.
Not in
assessee,
this
my lord.
case.
Not in this case, my lord. But
By-
here,
By this appellant?
no, my lord. Not by this appellant, my
But
lord.
tell us one thing.
But however, my lord, the
And also, my
Income
lord-
Tax Appellate Tribunal directed this.
No, but the only thing is, see, if you see para 13,
12.
para 13, the court has yet to be examined by the constitution, validity of the explanation. Constitutional courts. So if you are within your rights, you would do it.
And even otherwise, my lord, this writ petition was filed, my lord, against the order of the CIT appeals. Learned single judge says, my lord, you have efficacious remedy. You go, for first thing is you have not raised the issue.
Have they gone to ITAT? Have you gone? See paragraph 15.
And they have gone, my lord, they were granted relief on merits and revenue filed an appeal. That appeal came to be dismissed on monetary limits.
So what remains in
Nothing
this?
remains.
My lord, in this matter, senior counsel, Mr. Shankar is briefed in
Very
this
well.
matter.
Let's put it to you this.
Please, my lord.
You were given liberty in paragraph 15.
Yes, my lord.
We have been informed that you have availed this liberty. You went to ITAT. ITAT has granted you relief. The revenue has gone in appeal. Revenue's appeal has been dismissed. So why should this appeal be pending now?
My lord, otherwise this matter may have taken up 2:30, my lord.
Yes, we'll take it at 2:30. Call the
2:30.
council, 2:30.
Please, my lord. Please,
Pass over.
please, my lord.
Six urgent, 36 urgent, 37. May Rajkumar. 37.
Yes. Is it admitted appeal?
Yes, ma'am.
We'll just pass over the matter. Want to argue, now ready? We'll just pass over.
38, Shri Raghavendra.
Appearing for the appellant, my lord, kindly be pass over at 2:30. Senior advocate has been engaged.
Pass over.
Public.
39.
Lord, a short accommodation may kindly be granted in this matter, because what has happened is that the paper books, Lord, that has been misplaced while shifting my office recently, my Lord. This way.
At the request of counsel for the appellant, re-notify on. Submissions be filed by the counsel for the parties along with the judgment they want to rely on. You appear for the state, no?
No, no, not in this.
You don't appear in this?
In 40 minutes, I was just preparing.
11, 12. Serial number 40,
The appellants, my lord, I see.
40.
For a passover, my lord. Senior is on the legs. and
Pass
other-
over.
41.
My lords, in 41, I appear for the respondents, my lord.
My lords, we are filing an amendment application in this matter, my lords. There has been some sort of an error on my part, my lords, on annexing the impugned order. What we've done is, my lords, we've annexed an impugned order subsequent to the impugned order, my lords. So that's an amendment application that will carry out.
The request of counsel for the appellant.
May I make a submission, my lord?
Yes.
Kindly see that this has been heard 3 or 4 times. They wanted to argue it, and kindly see the title also. It is referring to the particular order of the tribunal 1431 Bangalore 2019. This cannot be amended. This will have to be dismissed, and they will have to avail of whatever remedies they have, is my submission to the honorable court. This has come a couple of times. Every time they give some new reason, because last time they said
Did
senior
you ask
standing
for
counsel.
time on this ground earlier?
No, no,
Yeah,
I'm not.
on 3 times they have asked, my lord. On the
Yes.
last occasion, he says that the senior will argue. Kindly see the proceeding sheet record. We have no problem if the honorable court feels it is to be given. I'm nobody to stand in the way. But
No, we just
4
want to know.
or 5 times I appeared.
No, we just want to see, and maybe possibly appropriate for you also to see what amendment they are seeking once an application comes. Possibly what you are saying.
May request this, my lord. Kindly have the impugned order. It only says there is a name change application. It is infructuous. With great respect, I have applied my mind. I am making the submission. Rest is I leave it to the honorable court. Kindly see the 2-page order at annexure
Yes.
G. It only says a name change application has been filed. Kindly see page 65. That is the para 3 I am reading. We on the perusal of the letter and the submissions of learned authorized representative found that the new Form 36 was filed by revenue in the name of so-and-so, formerly known as so-and-so. Further, the coordinate bench of the ITA in 42 for assessment year so-and-so has pronounced the decision on 28/6/2019. Whereas against the order of CIT appeal Bangalore, revenue has filed the appeal and tribunal has dismissed on 28/6/19. Further filing of second appeal by revenue against the same order for the assessment year shall not hold good and is infructuous. Accordingly, we dismiss the appeal as infructuous. It is only a name change application which they numbered it separately.
Just 1 minute.
And this has been rolling on from hearing to hearing.
Just 1 minute. So is this impugned order says your first appeal got rejected? And this second appeal, which you have now filed under a new form, there is
Yes,
some
my lord.
form, I think
Because
format
the-
given.
What is an error on our part, my lords, is the impugned order in this appeal right now, my lords, not the impugned order, my lords. If you look at the questions of law, my lords, the questions of law have nothing to do with the impugned order. There was an error on our part, my lords, at the time of filing.
The questions of law.
Please look at page 6, my lords, of the
Page.
page 6, my lords, of the appeal memo.
No, but besides that,
So that is the problem, my lords.
no,
See,
forget it. Given the fact no question of law arises. No, are the questions of law relatable to the ground on which the tribunal has rejected your appeal? What does it say is you filed an appeal under a particular form. It rejected it. Now you want to file a fresh appeal under a different form. But the subject matter of the appeal in both the cases is the same which was initially filed. Before against the order of CIT appeal.
Yes, my lords.
If that be so, in substance, challenge to that order of the first appellate authority has been rejected.
Lords, may I say this, my lords? Initially, my lords, we had filed an appeal, my lords, against the order. That is order dated, my lords, 27/11/2019, my lords. That is an order against the assessee. My lords, we had to impugn that order, my lords. But we had not, my lord. We have not filed that order, but our substantial questions of law, our grounds are all on that particular order, my lords.
Which dated?
That is, my lords, 27/11/2019, my lords. Oh, sorry, my lords, 28/6/2019. It's the same assessee. Well, I have the impugned order, my lords, the original copy at the
But
time.
see page 63.
Yes, my lords.
Now, paragraph 2. After hearing the author of SSC letter submitted that for the same in the honorable tribunal revenue appeal passed on this, whereas the revenue has to file a revised form on perusal of revenue is refiling the appeal in the new name. The letter is this.
So
The perusal of the submissions authorized appendix found that the new form this was filed by revenue. Further, coordinate bench of the ITA in this pronounced decision on 28th. Whereas against the order of this file an appeal has been dismissed on 20th. Further appeal of the second appeal revenue against the same order for the SMO shall not hold good and is in.
Yes, my lords. My only thing, my lords, my appeal right now, my lords, is against the order dated 28/6/2019, my lords.
What were the earlier appeals? They were the same.
Well, that is what I'm impugning, my lords. That is order dated 28/6/2019. That dealt with the merits of the matter.
Right. The first order or the second order?
The first order, my lords. And this appeal is also dealing with the first order only, my lords.
So you are not coming against this order?
This order I'm not, my lords. But inadvertently, my lords, I have annexed this order, my lords. That is
You're not coming against 27/11/19?
No, my lords.
Huh?
No, my lords, I'm not, my lords. That is an error, my lords, that we have committed.
Let's see your prayers.
27/11. But this question of face, my lord. This is what I'm trying.
What happened to the earlier appeal
Good file.
My lords, the questions relate to the first order, my lords. In fact, my lords, this order, my lords, Annexure C does not refers to the substantial questions of law or to the grounds, anything of that nature, my lords. But that it was a mistake on our part, my lords, that we did not annex the right order.
May I request my lords to kindly see court proceeding sheet of 22nd August 2023. From that day, this is continuing, that there seems to be a separate appeal for it. I'm sorry. I'm sorry.
Yes.
I'm sorry.
28/6/2019 was an order on merits also.
Merits, my lords. That is an order of merits, my lords. And on which, my lords, substantial questions have already been framed in this matter.
Then this prayer must also undergo.
Yes, my lords.
See, then appropriate will be, why don't you withdraw this and file a fresh appeal against the earlier order of 28/6?
So there's a inevitable delay, my lords. Delay of.
But delay would still come. Even an amendment delay would still.
Yes.
So better would not be that.
No, I thought I'll take instructions. If I have to withdraw this, I'll file a fresh.
That would be more, otherwise lead to confusion. You have to change your prayer clause.
Yes,
You have to bring in fresh grounds on 28/6 because that's on merit. On 27/11, there is no.
No, I'm not challenging
merit.
27/11/2019 order.
That's right. There is no merit also. There is nothing of that.
Nothing on it.
So you have heard him now.
My lords, yes, my lord, kindly see 22nd August 2023 court proceeding, my lord. The court record of 22nd August 2023, my lord.
That's right.
This is
Mr.
continuing
Rao.
for last 1 year plus. 1 year plus.
You are right. You are right. What you are saying is, now this appeal
My lord.
is on challenging 27/11/19. He says.
Yes, my lord.
He says, I have no grievance with 27/11/19.
Yes, my
But
lord.
the grievance is primarily against 28/6/19, which was a decision even on merit.
Yes, my lord. They can file separate appeal. They would have already filed.
That's what
Now
we
they
have
cannot.
conveyed to. One
Yes,
minute.
yes,
That's what
yes.
we have conveyed to him.
Okay.
Will that not be
Okay.
appropriate? They withdraw this appeal, file a fresh appeal, maybe with a condonation against 28/6.
That is what I am also submitting to the court, my lord.
He
That is my
wants to-
prayer to the court.
He wants to take instruction, let him take it.
Very well. Kindly keep it as the last year, last this thing, my lord, because the same thing is continuing
Yeah, we
from
will.
August 23. Kindly see the proceedings.
No, we will say so in our.
That is my
order.
prayer.
Just hold.
Obliged. Obliged.
This present appeal has been filed challenging the order dated 27/11/2019 for the assessment year 2011-2012. The Lena Council for the appellant submits that the appellant should have challenged the order dated 28/6/2019. 28/6/2019, which is an order, which is an earlier order passed by the ITAT in an earlier appeal, dismissing the appeal filed by the revenue on merit. Full stop. He seeks some time to take instructions to withdraw the present appeal and to file a substantive appeal against order dated 28/6/2019. Full stop. At his request to take instructions, re-notify on.
11/11.
Obliged to my lords.
Maybe not. Maybe after that, my lords. 11/11, my lords.
Just give thereafter.
25th, my lords.
25/11. Serial number 42.
For the respondent, I'm left by senior counsel, Mr. Srinivas Raghavan. He has some inconvenience and in the afternoon he has a part-heard matter, my lords. Requesting for adjournment, date may be fixed, my lords.
On the last one, some urgency, I'll just explain. On the
These
last
are
occasion-
date given matters.
That's right, my lord. On the last occasion, in fact, this was the same ground on which it was adjourned, and parties had agreed with counsel's convenience that the matter will be taken up today. In fact, the concern is this: on the previous, last but the earlier hearing, my concern has been noted by this honorable court. What has happened is, I am just briefly 2 minutes. Eventually, if the time has to be granted, my lord, I am in my lord's hands. I was a successful claimant in an arbitration arising out of a settlement agreement between the two of us. I am a contractor providing services to them. We had disputes. We entered into a settlement agreement where the tender was from the government.
What he said is, I will get the money from the government. We will open an escrow account. Whatever money comes from the government, we will share it in a particular proportion, which is recorded in a settlement agreement. He took me for a ride. The money came from the government. He diverted the money and took it away elsewhere. It did not come into the escrow account. I initiated arbitration proceedings.
That MOU was having an arbitration clause.
Yes. So I initiated arbitration proceedings. They participated. The arbitrator has simply implemented the settlement agreement. He says, you have already arrived at an understanding. This is the manner in which the money has to be shared. So you share it. So what they have received from the government, a portion of it they're entitled to retain, a portion of it they're required to pay to me.
What happened to 34?
In 34, the 34 court simply supplants the view of the arbitrator and says, no. The learned arbitrator could not have done this. There is no reasoning. There are two paragraphs of the section 34 code.
Which order? Where is the page?
Para 35.
No, where is the 34 order?
34 order, my lord, I take my lord. My lord will give me a minute.
29.
29 minutes of the appeal.
Not my copy. 29. This is not my copy. This is my copy. My lord, at page 54, internal page 26, at para 35. Para 35, there are two grounds on which the 34 court interferes.
But tell us one thing. Is it the conclusion drawn by the 34 court that deholds the settlement agreement, no amount should come?
No, that is not the view of the 34 court does not take a view that what ought to be done. The 34 court merely takes a view that what has been done is incorrect.
Under 34.
Under 34. It does not say what ought to be done. It merely says what has been done by the arbitrator is incorrect without any reason. Whereas on the other hand, on the issue of sharing, the learned arbitrator has given detailed reasonings at paras 82 to 89 of the award.
You have filed your submissions now.
I have filed my written submissions also.
You have also filed, no?
We have also filed.
Just say the request of learner counsel for the respondent re-notify for hearing on. See, we are giving a date, no adjournment.
Definitely.
My lord, just one observation. In the meantime, what is going on is, I'm in my lord's hands. In the meantime, somebody had initiated, and it is my case that they had put up somebody to initiate IBC proceedings against the company before the NCLT. If that were to succeed in the IBC, this company would disappear. And if a revised plan comes into place for revival and rehabilitation, so then I interfered in those IBC proceedings and I opposed, contending that
pleaded yourself there.
Yes, and contending that that's a fraudulent petition for the purpose of deliberately winding up this company. I succeeded. The NCLT has set aside those IBC proceedings. They have now gone in appeal before the NCLAT. Now there is no moratorium. Therefore, these proceedings can continue. My concern is, while taking adjournments here, they will continue to press the NCLT.
What is the date before NCLT?
Tomorrow, my lords.
That's
tomorrow.
That's my concern.
And
don't do anything there.
Even we are not. We are not challenging the NCLT. We are not before the NCLAT. It's the financial creditor who has appealed that order against the NCLAT. And the stay has been granted only on the penalty, my lords. The matter is being heard there before the NCLAT.
We have not challenged before NCLT.
No, my lord.
No,
The financial creditor.
They will not. The financial creditor set up by them. And my case before
That's
the
their
NCLT.
case, my lord.
That's too far and
No. My argument before the NCLT was that the FC who has come before against them is a person set up by them, and the NCLT has agreed with me. I have produced those orders, my lord. In fact, on the last occasion, I was asked to produce.
So with that petitioner before the NCLT, you have succeeded.
That's right.
Very well. The appeal is there that fellow has gone. Maybe possibly you'll reiterate all. We say
maybe.
Nothing. What is the date tomorrow now?
Tomorrow.
We'll give you a date. Just give date, ma'am, after 3 weeks or 4 weeks. Give it in first week of December.
4/12. Sir, 4/12.
We'll have it. That we can't say anything on NCLT. You have to possibly, work it out there only.
Even we have not challenged it, my lords. And
He says proxy.
That's right. That's their case, my lords.
Obviously.
So 412, no further adjournments. If an observation can be made with the last 2-3 times.
You can just say this, the no further adjournment shall be granted on the next date of hearing.
Great.
Okay?
Great.
Yeah. Thank you. Next.
43.
Appear for the appellant in this case, my lords. This is an appeal arising out of a dispute between KPTCL, which is a government company, as well as the Department of Commercial Taxes. The present case, my lords, I believe there is a new dispute resolution policy of the government.
What has to be done in this?
Interdepartmental disputes.
This is a fit case. Both the entities are under the state government.
Yes, my lords.
It's a fit case where the highest of the person, the chief secretary or someone must look into it. See, ultimately, these things need to be worked out.
There's an interdepartmental mechanism, my lord.
So then,
I'm in your lordship's hands, my lord, because
why you should be? You have to do it. We are not. We are.
I mean, unfortunately, the respondent
This has to be worked out at your levels.
Yes, my lord. In fact, I had suggested that it be worked out. The
Please, my lord.
initiative may have to come from the appellant. That's the limited point.
We don't.
My
know.
lords,
We don't know. This you will suggest what do you intend to do? We will not say anything on this.
Because I'm ready on the merits. As it is, there are no merits, and I'm open to your lordship's.
Why should even the merits be argued?
Very well. In fact, the suggestion had gone from me to the department, and it was considered.
Who is the officer? Will ask the officer to come here then.
Very well.
Will ask the officer to come here. Was it put up also to the officers? Was
In fact, this morning,
this
if-
is taken at the highest level in both the organizations and then be placed before the highest of the functionary to work out.
If I may just make a submission, my lords, we did have one round of discussions with the department, my lords, but they pleaded their inability to do anything on the ground that the appeal period had expired by the time we filed the appeal. Therefore, my lord, I am also completely in agreement with my lord's suggestion that it has to be worked out as per the dispute resolution policy between the departments. But the only question that
in place.
There is a policy.
Yes, my lord. Why is the policy not acted upon?
It has climbed the rungs of the mechanism, my lord. There is no. It should have been resorted to.
Just an initiative, Just an initiative.
Absolutely. In fact, my lords, if my learned friend is fair enough, he'll recall that I had called him the last week to Please, my suggest lord. if this was a possibility. Indeed, my lords. I took instructions from my client. We are more than agreeable to go before the dispute resolution committee as per the policy. The only.
You suggest what do you want?
Your lordships may make an observation that the parties will explore resolution within the policy and post it after maybe about 4
He
weeks.
will not say anything. We will record your submission and then send it. No, we will say that since this dispute pertains to the entities under the state government, they want to work out an internal mechanism in terms of the scheme. What is the scheme?
The specific.
We'll take instruction because we'll bind you to your statement.
Of course.
So take instructions, whoever has to give, take a written instruction, we'll put it on record.
Your lordships may have it on Monday, then I'll take it.
Yes, you have also must take your instructions.
Please, my lords. My client is already in principle agreeable to going before the committee, my lords. There are only just
say
3
that's
requests.
At the request of counsel since the petition appeal pertains to two entities under the state government, the counsel for the parties seek some time to take instructions. At their request, re-notify. Just give a convenient date, this month only.
25/11. 25/11.
Oblige.
44 adjourned.
I make one request, my lord. Serial number 19. What happened is the arbitration proceedings papers could not be traced. Only humbly request to have it 2 weeks later. I will try to trace them and argue the matter. If not, also I will argue the matter. I've
You
been
say
request-
19.
Yes, 19, my lord. I've been requesting my friend also to supply me the copies. I'm handicapped, otherwise I would argue the matter.
This is a GST.
Not GST,
That
the
sales tax, my lord, on
not sale,
buses
not,
were.
not the sale tax. See, the one is of concerning sale tax. We are not liable to pay them because as per the contract, entire tax must be paid by them. The other is connected with the service agreement. Service agreement. In the service agreement, there is two classes. One is service payment at the particular rate for 3 years and at a particular rate for next two years. Now the arbitrator has granted the service charges at the rate which is fixed for the 4th and 5th year.
At the request of counsel for the appellant, re-notify all. Counsel for the parties to file their written submissions along with the judgment they want to rely on. Next.
512,
Obliged.
Obliged.
serial number 27.
Appearing for the
27.
respondent. My lords, appearing for the respondent, my lords, it appears that no counsels are available.
Just say Passover, just say Passover.
Oh.
Let's
28. 28,
Passover.
35. 35, Shri Dilip.
Just say Passover.
37.
Yes.
But this is an appeal from an order passed under section 263, revising the assessment. My lords, in connection with certain claim for deduction that I had made for assessment year 8-9. I'm in the business of marketing certain health products. But for that purpose, I have offices all across the country. These offices are taken on lease for short durations between 36 months, 48 months, 60 months. But there are certain expenditure which is incurred when I take these premises on lease for making them fit for my office purposes. Under the lease agreements, I cannot carry out any permanent alteration to the structure. It can only be temporary alterations which are there. And at the expiry of the premise lease, I have to hand over by removing all these structures which are there. Because I have been claiming this expenditure as a deduction by taking them at 100% depreciation as temporary structures. So these are partitions, wood boards, my lords, false ceilings, etc. Because that was allowed. I was initially assessed in Delhi. That was allowed for the first 2 years, 2000, 2001, 1-2. Thereafter, there was no dispute at all. And even for this year, the assessing officer asked me for details of fixed assets which are capitalized in the books. I gave him those details. And as I had claimed 100% depreciation, he allowed it. Because the commissioner revised by invoking the power under section 263 to say that these are to be treated as parts of building, and hence you are entitled to depreciation only at the rate of 10% and not 100% as I claim. The tribunal has, and they said that, well, the tribunal has affirmed the view taken by the commissioner, and I said two things. One is that admittedly no inquiry was made by the assessing officer when he passed the order. And secondly, they said that the order for the earlier years of the tribunal should not bind us because each year is a different year. So we are in appeal on this issue.
Where is the earlier view?
Well, as the earlier view is, I think, accepted by the tribunal, by the department. They did not go to the High Court. My lord will just see this order which was passed. on identical facts, these are also similarly
Absolutely, absolutely.
partitions.
My lord, just see.
Tell us in law, when it comes to a issue like this in an income tax matter, what are the principles which governs when an issue is identical but between two assessment years?
Well, it's really what the Supreme Court has held, that there should be some, unless there is some change in the facts or in the law, the earlier view should prevail. Because otherwise there is no reason why you should depart from this view matters. In fact, my lord,
There is no change in law according.
nothing. But just see para 19 of this order.
Was this taken in appeal before the?
To the best of our knowledge, it's not been carried further.
Pardon?
To the best of our knowledge, it's not been carried. We've not been served with anything. If they filed an appeal which got dismissed for non-removal of objections, or at the admission stage itself before service, it got dismissed, I don't know.
Now, what is the finding of the ITAT on this?
Well, just see para 19 of this order first, man. Just to satisfy my lords that it's identical. Ground numbers 9, my lords, at page, I'm sorry, it's not paginated.
Yeah,
It's
we
at
have
running page 136.
That's right.
Ground number 9 and 10 relate to the disallowance of rupees so-and-so made on account of leasehold improvements. The SSE had claimed a deduction on leasehold improvements. The explanation of the SSE was these expenses were incurred for temporary structures, hence were of revenue nature. The details of expenditure were furnished. The officer found that the expenses were mainly for fabricating the fixing work of blackboard, drawer unit, partition, storage units, etc.
So the common is partition.
Partition, my lords, blackboards also, expenses for civil work, suspended ceiling, flooring, furniture, and so on. The officer was of the view that these expenses were of capital nature, hence disallowed the same. The CIT appeal, after considering the submissions of the SSE, obtained a remand report from the assessing officer. After considering the submissions, she allowed the claim to the extent of 42 lakhs and disallowed the balance of 41 lakhs. The learned counsel took us through the lease agreement entered into by the SSE with the lessor of the property. Our attention was drawn to the details of the expenses placed on record. Reliance was placed on a judgment of the Patna High Court in so-and-so. Contention of the learned DR was that the expenditure was of permanent and enduring nature, hence the disallowance was justified. On a careful consideration of the matter, we see no reason justification to uphold the part disallowance of the expenditure. Firstly, it is on record that whatever expenses were incurred, they were to make the property suitable for use of the SSE. In other words, the SSE made the improvements to facilitate its day-to-day working so that it can run the business smoothly. In the process, it may have necessitated to put up temporary structures like wooden partitions, etc. The lease agreement provides that at the time of vacating the same, the SSE will be entitled to remove and take away all that may have been installed or attached or brought to the demised premises. Further, the initial lease period was for a period of 36 months. Thus, it can be presumed that the SSE would not put up any structure which is of a permanent nature, which it cannot remove while vacating the premises. The segregation of the expenses by the CIT appeals to allow part of the expenditure is without any basis, and it is difficult to conceive that the two parts segregated by her were totally independent of each other. In other words, the entire expenditure has to be treated as a composite expenditure incurred only to facilitate the business of the SSE. Therefore, we direct the allowance of so-and-so as revenue expenditure. This was the finding of the tribunal for assessment year 2000-2001, which was reiterated in the 2001-2.
And not a capital.
That's right. Now, if my lord will just see page 56 of the current, page 50, my lord's first page 50 of the present appeal papers. Because after the original assessment was framed, the officer wanted to rectify his order. So he issued a show cause notice to me, which is, my lord will find at page 50.
What was the earlier view?
It was,
which he wants to rectify.
Well, he had allowed it in the original assessment.
Oh, he allowed it.
He allowed it. Commissioner, my lord, he then wanted to rectify. My lord will see page 50. The particulars of mistake proposed to be rectified is excess depreciation.
Yes.
Allowed. Then my lord will just turn to page 51, which is my reply to this.
But after considering my reply, no, that page 53, if my lord will just turn page 53. The company is engaged. Has my lord got that? Halfway down the page. The company is engaged in the business of distribution of weight management products and operates through distribution offices located at various cities across India. These offices are taken by the company on cancelable operating lease, and the periodicities of the lease generally vary from 36 to 48 months. The said lease agreements inter-alia have the following clauses in relation to alterations, modifications to the lease premises. The company shall not change or make any permanent alterations of any structural kind or nature in the lease premises or any portion thereof. The company is permitted to make partitions, any additions or alterations which are of a temporary nature to suit its convenience in accordance with the relevant local, state, municipal or central rules and regulations. On expiry of the lease
But
period.
you did not rely upon the ITAT Delhi.
My lords, we had referred to it, my lords. Just see at page 54. At this juncture, last paragraph, second last paragraph, my lords. At this juncture, it is also important to take note of the order passed by the tribunal. And we pointed out what was the nature of the work.
Now, what is the finding on this ITAT and on this?
Right, ma'am. My lords, please see the tribunal's order, the impugned tribunal's order. My lords, the order starts at page 73.
73. And just show us this how does it distinguish?
That's right.
Come to 72.
Right, ma'am.
SSC has placed reliance on various judicial pronouncement. It was also mentioned ITAT this.
Right.
As well, that issue in favor of the SSC.
No, that is the Commissioner's 263 order in revision, which gave rise to the filing of the appeal, my lords.
Whose findings? This is basically summarizing the submissions, summarizing the findings.
My lords, page 70 is the Commissioner's order under 263. My lords, at page 72, my lords, and para 5.2, he says that you have not examined this issue. And then my lord will just turn to para 5.3 at page 73. The SSC's reliance on the ITAT decision in its own case is of no consequence, as the nature of expenditure on leasehold improvements may be different in each year, and the same was not examined by the assessing office. That is all that he says. And my lords,
Tell us one thing, the properties are different, no?
Because the property, the leasehold will be different. Right? The leases, but the principle is the same. My lords, I take them up for 3 years or 4 years. When they get over, if he doesn't renew it, I have to go to another premise. There again, I'll have to incur the same kind of expenditure. And my lords, just consider this. This is assessment year 8-9. There is no dispute that I either get the entire cost in year 1 or I get depreciation over a period of years. By now, today, otherwise, what you will have to do, because that's what we had pointed out on the earlier occasion when this matter had come up, that really by now I would have got depreciation in its normal cost also at 10%. Well, it's really today, this 1 year has been challenged. Now, if my lords, I fail on this, every year they'll have to reopen the assessments to give depreciation for each year, because that has not been done. What is the whole purpose of this litigation? Well, it's really, it is revenue neutral in the ultimate analysis. The cost has to be allowed. Well, the rates of tax have remained more or less constant. Well, please just see what the tribunal says, my lords.
But what happened between 99, 2000 and 2000? This is 2008 and 9. What happened in between?
There all years it has been accepted.
Followed the Delhi view.
But there is no disallowance made by the assessing officer. 2000, 2001, 1, 2, it was accepted. The decision of the tribunal was there. Thereafter, there has been no dispute. 8, 9 also the officer allowed it. It is only the commissioner who sought to revise.
saying that the assessment order is erroneous and prejudicial to the interest of the revenue.
Are there any other judgments of any other court?
Well, this court has taken, this court has taken the view.
Was that?
Well, I'll show my notes. And NCA. Well, this is a judgment of this court in Infosys Technologies. If my lord will see the penultimate page of the order, paragraph 12. This is an NCR. My lords has got NCR. I'll read NCR then first. Lords, please see NCR question 1 at page 2.
Yes.
Whether the tribunal is correct on facts and in law in holding that the expenditure said to have been incurred by the SSC amounting to so and so on improvement of interiors, electrical works, modeling and networking of computers, workstation and other miscellaneous works in a lease premises is revenue expenditure without appreciating that the one-time expenditure incurred in providing necessary infrastructure resulted in a benefit of enduring nature which will be available to the SSC for many years. Well, the discussion starts, my lords, from paragraph 4. My lords, will just see.
Broadly, what is the work is improvement of interiors.
That's right.
Broadly.
Well, just see para 5, they've set out what is the nature of the expenditure. On the other hand, learned counsel for the SSC has pointed out that the premises were taken on lease for a period of 3 years. Expenditure was incurred towards purchase of workstations, improvement of interiors and electrical works, fees paid to architect, cabling work for networking of computers in connection with setting up of the office. Therefore, the same cannot be treated as a capital asset. Further submitted that the SSC only derived business advantage on account of expenditure incurred in leasehold property for improvements referred to certain decisions. And then my lord will see the court's conclusion from paragraph 6. We have considered the submissions made on both the sides and have perused the record. Admittedly, in the instant case, the SSC had incurred expenditure towards purchase of workstations, improvement of interiors, electrical works, fees paid to architect, cabling work for networking of computers in connection with the setting up of office. The test for distinguishing capital expenditure or revenue expenditure was laid down by the Supreme Court in Assam Bengal Cement Limited, which laid down the test which reaches under. Then they set out the test. The aforesaid principles were referred to with approval in Madras Auto Services Private Limited, Supra, on the touchstone of the aforesaid well-settled legal principle. If the facts of the case in hand is examined, it is evident that the expenditure SSC has taken premises on lease for a period of 3 years, and it had incurred an expenditure for improvement of the leased premises. The premises did not belong to the SSC, and the expenditure did not bring into existence any capital asset of the SSC. The expenses were incurred for conducting the business of the SSC more profitably and more successfully. The SSC therefore got the business advantage, and therefore the tribunal has rightly treated the expenses incurred as revenue expenditure incurred for improvement in leasehold property as revenue expenditure. This takes us to the second substantial question. We did not consider.
8 is not relevant.
One is not relevant. And my lord, see the earlier judgment of this court in Infosys, paragraph 12 onwards. These questions, has my lord got that? Paragraph 12, the penultimate page.
Yes.
These questions involve validity of the order of the tribunal, holding that the expenses of so-and-so incurred by the SSC towards brickworks, cement, plastering, painting walls, laying ceramic tiles, MS grill, internal sanitary fixtures, sewerage works, supply and fixing of water supply pipes on leased premises would not amount to major repairs. The AO held that the said expenditure incurred on the extensive repairs are enduring in nature. Therefore, it should be treated as capital expenditure in view of the judgment of the Supreme Court in Balimal Naval Kishore, the appellate authority held that the said expenditure incurred by the SSE towards renovation of the premises taken by it on lease for a period of 6 years, no doubt, no advantage of enduring benefit is derived. The appellate authority further held that the said repairs are carried out by the SSE in a lease building for the purpose of business and confirmed the order passed by the AO, holding that the expenditure incurred by the SSE is capital nature. However, allowed the depreciation at the rate applicable to buildings. The tribunal held that the said expenditure is not of an enduring nature, and having regard to the explanation offered by the SSE that the premises required repairs when it was taken on lease, and in order to improve the ambience of the office of the SSE to be housed, it was necessary to carry out the repairs as the same was necessary for the purpose of business, specifically in the business of software, where there is stiff competition, and the mere fact that enduring benefit itself would not be a factor to be decided as to whether it is capital or revenue expenditure. The tribunal has held that the said amount cannot be said to be capital expenditure, only a revenue expenditure. The decision of the Supreme Court in Balimal cited supra is not applicable to the facts of the case. It is clear from a scrutiny of the material on record that the expenditure incurred by the SSE towards repairs and renovation of the premises to house the office of the SSE cannot be said to be capital expenditure having regard to the facts of the case. As it is clear that the premises had been taken on lease, it required extensive repairs and renovation, and the same has been done in connection with the business of the SSE to improve the ambience of the office, and the expenditure was revenue in nature, and the expenditure was wholly for the purpose of business as the premises had been taken on lease. The mere fact that it was taken on lease for 6 years would not itself render the expenditure capital in nature. The decision of the Supreme Court in Balimal referred to supra is not helpful to the revenue. In the present case, as in that case, that premises that was purchased was a ginning factory, and the factory was converted into a cinema theater by extensive repairs and by expending substantial amount towards machinery, new furniture, replacement of electrical wiring, sanitary fittings, etc. In addition to extensive repairs to the walls, to the flooring, to the hall, to the flooring and roofing, to doors and windows, and to stage sides, and having regard to the consideration amount for which the property was purchased and the amount of repairs carried out, the Supreme Court has held that the expenditure was capital nature and as there was enduring benefit to the property. However, in the present case, the premises has been taken on lease by the SSE, and the repairs that are carried out for the purpose of...
Mr. Padival, we have seen it. We have... Now, any other thing, any other judgment you want to rely?
Yes, my lord. My lords, even the Supreme Court, my lords, you can just point out the judgment where they said if an issue is revenue neutral, you should not needlessly litigate on these aspects.
Yes. We'll come back after lunch.
Certainly.
Apologies, Mr. Pardiwala.
No, not at all.
We had a meeting and it
No problem.
just struck me that I should have informed you.
No issue.
Yes.
No, I was on the judgment of the Supreme Court in Excel Industries, just the principle that they laid down therein. So just see para 31 and 32. Yes, ma'am. At page 7. It appears from the record that in several assessment years, the revenue accepted the order of the tribunal in favor of the assessee and did not pursue the matter any further. But in respect of some assessment years, the matter was taken up in appeal before the High Court, but without any success. That being so, the revenue cannot be allowed to flip-flop on the same issue, and it ought let the matter rest, rather spend the taxpayers' money in pursuing litigation for the sake of it. Thirdly, the real question concerning us is the year in which the assessee is required to pay tax. There is no dispute that in the subsequent accounting year, the assessee did make imports and did derive benefits under the advance license and the duty entitlement passbook and paid tax thereon. Therefore, it is not as if the revenue had been deprived of any tax. We are told that the rate of tax remained the same in the present assessment years as well as subsequent assessment years. Therefore, the dispute raised by the revenue is entirely academic, or at best may have a minor tax effect. There was therefore no need for the revenue to continue with this litigation, when it was quite clear that not only was it fruitless on merits, but also that it may not have added anything much to the public coffers. It's just the principle what my lords had asked me in the morning, that what should happen if there are different years, what view should be taken. And then my lords, because this is an appeal from an order passed under section 263, if my lord will just see section 263 for a moment.
But the tax effect is, would be substantial.
No, it's a question of deferment.
10% depreciation, 10%.
But my lords, over a period of 10 years, I'll get the full cost as a deduction. The cost is allowed as a reduction, whether I get it in year 1 or I get it over a period of time. Let's please see section 263.
Yes.
The principal chief commissioner or chief commissioner or principal commissioner or commissioner may call for and examine the record of any proceeding under this act. And if he considers that any order passed therein by the assessing officer or the transfer pricing officer, as the case may be, is erroneous, insofar as it is prejudicial to the interest of the revenue, he may, after giving the assessee an opportunity of being heard, and after making or causing to be made such inquiry as he deems necessary, pass such order thereon as the circumstances of the case justify, including an order enhancing or modifying the assessment or cancelling the assessment and directing a fresh assessment, order modifying the order under 92C, etc. So, there are two conditions which are jurisdictional. The order must be erroneous and it must be prejudicial to the interest of the revenue. Both are fundamental principles which have to be applied. And that is what the Supreme Court has laid down. My lord will just see the judgment of the Supreme Court in Max.
Yes.
Now just see the short judgment, if I can just read 2 paragraphs. In our view, at the relevant time, 2 views were possible on the word profits in the proviso to section 80 HHC3. It is true that vide the 2005 amendment, the law has been clarified with retrospective effect by the insertion of the word loss in the new proviso. We express no opinion on the scope of the said amendment of 2005. Suffice it to state that in this particular case, When the order of the commissioner was passed under section 263, two views on the said word profits existed. In our view, the matter is squarely covered by the judgment of this court in Malabar and also by the judgment of the Calcutta High Court in the case of Russell Properties. At this stage, you may clarify that under para 10 of the judgment in the case of Malabar, this court has taken the view that the phrase prejudicial to the interest of the revenue in section 263 has to be read in conjunction with the expression erroneous order passed by the assessing officer. Every loss of revenue as a consequence of an order of an assessing officer cannot be treated as prejudicial to the interest of the revenue. For example, when the officer adopted one of the courses permissible in law and it has resulted in loss of revenue, or where two views are possible and the officer has taken one view with which the commissioner does not agree, it cannot be treated as an erroneous order prejudicial to the interest of the revenue unless the view taken by the income tax officer is unsustainable in law. According to the learned Additional Solicitor General, the interpretation of the provisions of 80 HSC 3 as it then stood, the view taken by the assessing officer was unsustainable in law, and therefore the commissioner was right in invoking section 263. In this connection, he has further submitted that in fact the 2005 amendment, which is clarificatory and retrospective in nature, itself indicates that the view taken by the officer at the relevant time was unsustainable in law. We find no merit in the said contention. First, it is not in dispute that when the order of the commissioner was passed, there were two views on the word profits in that section. The problem with 80 HSC is that it has been amended 11 times. Different views existed on the day when the commissioner passed the above order. Moreover, the mechanics of the section have become so complicated over the years that two views were inherently possible. Therefore, the subsequent amendment made in 2005, even though retrospective, will not attract the provisions of 263, particularly when, as stated above, we have to take into account the position of law as it stood on the date when the commissioner passed the order dated 5/3/97 in purported exercise of his powers under section 263 of the Act. So therefore, if two views are possible, then really 263 cannot be invoked. And that view was taken by this court.
How are you translating that proposition in the facts?
So, my lords, here if today the tribunal in my own case the tribunal had taken a view in my own case for the earlier two assessment years, that this is to be allowed as a deduction, then obviously it's a possible view. Frankly, there is no contrary view. It is only view. So if the officer...
It's not an erroneous view.
It's not an erroneous one.
According to you.
Absolutely. And please see the reasoning of the tribunal, my lords. If my lord will just quickly see the tribunal's order, starting at page 75. Because para 6.1 is the conclusion at page 79.
All these judgments were referred to. This what you have referred today, at least on merits.
My lords, it doesn't.
It's all right.
I don't think so.
It's all right. Yes, which page?
Right.
Paragraph?
Para 79, page 79, para 6.1. We have heard the rival contentions, perused and carefully consider the material on record, including the judicial pronouncement cited. The CIT Bangalore on an examination of the order of assessment passed under section 143(3) read with 144C, and the records of assessment was of the view that the assessing officer, while passing the order of assessment, neither made any inquiry nor applied his mind while allowing the assessee's claim for 100% depreciation on leasehold improvements, thereby resulting in the order passed being erroneous and prejudicial to the interest of the revenue. Further, we also observe that the statement of the CIT that the AR of the assessee in the course of the revisionary proceedings before him, while order sheet noting dated so-and-so, admitted that no inquiry was conducted by the officer in assessment proceedings in respect of the issue of depreciation on leasehold improvements has not been controverted before us. In this context, it would be relevant to extract hereunder the letter dated 15th July 2011 filed by the assessee before the assessing officer to show the details filed in response to the assessing officers as requirements during the scrutiny assessment proceedings. Then they extract from the letter. My lord will just see item 3 there on the next page. Addition to fixed assets. During the financial year 2007-8, additions aggregating rupees so and so have been made to the fixed assets. Details of additions so made during financial year 7-8, along with sample copy of invoices. High value items above 1 lakh is enclosed as Annexure 3 for your perusal. And then my lord will see on the next page, item number 6. Copy of major rent agreements in respect of rent paid by the company are enclosed. So the lease agreements were enclosed, which shows the terms of the lease, which shows that you have to remove you cannot make any permanent alteration. Only temporary changes can be made. And when you surrender the lease, you have to remove those alterations. Plus the details of expenses were filed. So they may not have been an actual that, no, you claimed the entire cost as a deduction. They may not have been an actual application of mind to that aspect of the matter. But the facts were all before him. And then my lords will see para 6.3. A perusal of the SSC's letter dated 15 July to the assessing officer Supras established that the SSC filed reply details in respect of the 7 issues listed therein. It is also apparent from a perusal thereof that the 7 items on which details were admittedly called for were certainly not with respect to an examination or inquiry with regard to the SSC's claim for 100% depreciation on leasehold improvements. We find that the order of assessment for 8-9 is also completely silent on this issue. Therefore, in our considered view, it is amply clear that the assessing officer has neither made an inquiry nor applied his mind in respect of the issue before us. All the averments to the contrary by the learned authorized representative are mere claims, which are bereft of any corroborative evidence whatsoever. The averments of the learned authorized representative to rectificatory proceedings are not material as the same is not before us, as the records of the subject matter before us are the order of assessment for assessment in 8-9 and the impugned order under 263. We therefore concur with the view and finding of the CIT that the officer did not cause any inquiry to be made in the course of assessment proceedings in respect of the SSC's claim for 100% depreciation on leasehold improvements, as there is neither a whimper or mention of this issue either in the SSC submission before the assessing officer nor in the order of assessment for assessment in 8-9. In this context, it is pertinent to note that passing of an order of assessment is the prerogative of the assessing officer. The SSC has no control over the assessing officer for passing the order of assessment in a particular specific manner. But if the discussion is not discernible from the order of assessment, then in order to ascertain whether the officer has applied his mind or not, the higher forums can go through the show cause notice issued by the officer and the reply given by the SSC. That would indicate that though the order of assessment is silent, but the issue must have been discussed and considered in the course of the assessment proceedings. In our considered view, the factual matrix of the case establishes that there is no such material or record to show that either such material was called for and examined by the officer or filed vide SSC's letter dated so-and-so, and therefore the order of the assessing officer on this issue is both erroneous and prejudicial to the interest of the revenue. As observed by the learned CIT, the SSC's reliance on the decision of the Delhi bench for assessment in 2000-2001 lays down the principle on this issue, but the actual nature of the items of expenditure on leasehold improvements may be different in each year, and the factual aspects of this issue, whether the expenditure falls in the capital or revenue field, have definitely not been examined by the officer in this year, that is assessment 8-9. Drawing support from the Karnataka judgment in the case of Infosys, we uphold the impugned order of the CIT, who has considered all the factual aspects of the matter before taking action under 263 on the ground that there was no inquiry or application by the assessing officer while allowing the SSC 100% depreciation on leasehold improvements, consequently finding no merit in the grounds raised by the SSC, the same are dismissed.
But Teller, did you take up this point before the authorities below?
Yes, my lord.
How do we get that?
Well, we have raised the issue that this order of the tribunal is there. See my reply to the show cause notice. My lord, just see the commissioner's show cause notice and my reply there too.
See what really.
My lord, please see page.
Now, if you see just only 6.1, Mr. Pardiwala, the impugned order of 6.1.
Yes, my lord.
Just come again on that. We have heard the rival contention, peruse carefully, consider the matter, including judicial. On an examination of the order of assessment, this records of assessment was of the view that assessing officer when passing the order of assessment neither made any inquiry nor applied his mind while allowing the assessee's claim for 100% depreciation on
Right.
leasehold improvement, thereby resulting in the order being filed. Further, we also observe that the statement in the above context, it would be relevant to extract here and there the letter filed by the assessee. Okay, okay. Now, see 6.3.
Yes, ma'am.
A perusal of the assessee's letter to the assessing establishes that the assessee replied details respect of 7 issues listed therein, even the rent agreements which you have said. Now read further. It is also apparent from a perusal thereof that 7 items on which details were admittedly called for were certainly not with respect to examination on inquiry with regard to assessee's claim of 100% depreciation.
So, but if he asked me for details of the fixed assets, if he asked me for full details of expenditure which you have capitalized, and he asked me for the rent agreements, what is the inference to be drawn? Because today he may not, I can't control the manner in which he issues a notice or he asks for particulars. He asked me for this. The presumption is that he wanted to verify my claim.
But see the next line, we find that the order of assessment of this
is silent.
Is silent on this.
But
issue.
that, my lords, that the our court has taken the view that, well, just see the judgment in, my lords, of this court.
Clear assessing officer neither made any inquiry nor reply. All the evidence to the contrary of the assessee are main claims which are bereft of any correlation.
Just see the judgment of this court in Sun Microsystems.
But was this a ground before the first appellate authority?
No, because it was allowed. There was no question of first appellate.
Okay.
Lord, may I intervene, my lord, make one submission. My lord, the scope of the appeal before the tribunal was whether exercising jurisdiction under 263 by the commissioner was correct or not. Merits were not looked into. Then subsequently what happened was, my lord, the assessing officer has passed an order. That probably would have been challenged in appeal. I don't know, because that was, I am told, my lord, it was passed on 28/12/2016. 28/12/2016. My lord, the commissioner directed the assessing authority to pass an order afresh after giving opportunity to the assessee.
On this issue also?
On this issue. This is basically, my lord, these whole proceedings are confined to, my lord, whether 263 order is valid or not. Subsequently, my lord, order giving effect has been passed. This is not an order of assessment. Subsequently, order of assessments have been passed. That probably would have been challenged. Now, my lord, in these proceedings, my lord, those subsequent orders cannot be set aside, my lord, which are passed after being heard. My lordship may kindly see, my lord, last portion of the order of the commissioner.
This was pursuant to that notice issued.
No notice issued. My lord, 263 order was passed, directing the officer to hear the assessee and pass fresh orders in accordance with the directions. That came to be challenged before the tribunal. Tribunal has said, my lord, the assessing authority has not looked into this. Has not made inquiries with regard to these specific items. That is, my lord, before my lordship's room. Now, subsequently, the assessing authority has passed fresh orders. Assessment orders.
Have you challenged those orders?
Yes, because there again, my lords, he's disallowed because the commissioner said that you're not
But tell us
entitled.
then, if they have been disallowed, will that not be a remedy thereafter?
No, but my lords, today, the fundamental, if he is exercise of jurisdiction in the 263, because if two possible views were there, and the officer took one view, then the commissioner could not exercise power under 263. Then that's the end of the matter. I don't have to go through a second innings again. Because my second appeal is still.
But what was the occasion for the assessment orders being passed thereafter?
That is because of the remand by the commissioner.
Right.
So if my lords holds that the commissioner's order was unjustified, then that order goes.
Okay.
And my lords will just see today, just see what this court has said. Just see the judgment in Sun Microsystems. Which paragraph? Well, just see paragraph 6. We are unable, paragraph page 5, para 6. We are unable to accept the said submission of learned counsel for the appellants, as by accepting the return filed by the SSE, in which requisite details had been given, it was not necessary for the assessing officer to give detailed reasons, although it could be said that had such reasons been given, it may have been better. However, the order cannot be said to be erroneous insofar as it is prejudicial to the interest of the revenue or taken up for revision under 263 of the Act merely because no reasons had been given, even though the order of the assessing officer was in terms of the amended provisions of 10(4) of the Act. As such, we are of the view that no substantial question of law arises. So today, my lords, if the officer has taken a particular view, which is an acceptable view, it may not be the right view, but as long as it is a possible view, then you cannot invoke 263, even though the order may not deal with the claim. And my lords, as I pointed out, after the assessment was over, he wanted to rectify. We filed detailed submissions as to why rectification could not apply, and then he didn't take any steps further.
Yes, that's all.
That's all.
Yes.
My lord, on the first issue, my lord, of the order of the appellate tribunal, my
Just
lord.
give us flats. First is assessment order, then notice. How it just show us those brief list, the dates.
The assessment order is dated 29th October 2012. The 154 notice proposing to rectify the assessment order is at page 35. The 154 notice proposing to rectify the assessment is dated 19th August 2013, which is at page 50. Well, it's 5th November 2013 is my reply to the rectification notice, which is at page 51.
Hmm.
26th February 2014 is the 263 show cause notice, which is at page 56.
Yes.
11th March 2014 is my reply to the show cause notice, which is at page 58.
Reply to show cause.
Commissioner show cause notice as to why revision proceedings should not be exercised.
Which page is this?
Page 58.
Hmm.
The 263 order is dated 17th March 2014 at page 70. And the tribunal order is dated 2nd February 2018 at page 75.
What was the on remand, the orders passed?
Whereas he disallowed it again.
What is the date of that?
I'll just give that.
Do we have the reasoning?
My lords, today it is still pending before the CIT appeals.
That's why, but what are the reasoning given?
Because he says it was an expenditure which gives enduring benefit, not a temporary one.
But the only thing is, Mr. Padiwala, tell us one thing. Once that is under challenge before the concerned authority, would you like to go ahead? You will have all the police available.
No, but my lords, the point is this, my lords, that happens in all 263 appeals, because in a 263 appeal, my lords, by the time the matter comes up before this court, the order giving effect is always passed because it has to be passed within 2 years. By the time the matter reaches here, it is always passed. So that doesn't mean that I can't argue it.
Reasoning given that order. Do you have that order?
No, I came to know, just got the instruction, it's passed. It's passed on 28/12.
No, okay, we don't want to see it. Let's not look into that. Broadly, what are the reasons given?
Bro, it is really a benefit of an enduring nature. It is not temporary and therefore it is capital. That is all. And matter went to because officer decided, commissioner decided against, matter went to the tribunal. Tribunal has said commissioner has not applied his mind, has been sent back again to the commissioner appeals. It is pending before CIT appeals again. So, to just avoid all this multiple.
Okay, yes.
Not so far as the Delhi tribunal order, my lord, judgment. Probably, my lord, what was decided?
Okay, the first one. Now, yes, how would you answer that?
Lord, probably it was below the monetary limit because what was disallowed was 41 lakhs and 41 lakhs for 1 year.
That's for those, no?
For filing appeal before the High Court. My lord, para 19, page, my lord, internal page. So disallowance of 41 lakhs probably, my lord, at 30% would come to about, my lord, 12 to 15 lakhs with interest.
Now, what are the additions which have been made for the usage of the property?
That is
in terms of the lease deed.
My lord, that is, my lord, so far the observations of the commissioner is that has not been examined by the AO. My lordship may kindly go to, my lord, the last portion of 263 order. That is in, my lord, page 73. The particular item has not been examined by the assessing officer. My lord, this one in Inc. 73. My lord, internal 4, page number 4, para 5.3. My lord, I will start from 5.2 earlier. Sorry, my lord. 72, para internal 5.2.
Just one.
Please. It starts from para 5.
No, this ITAT proceedings arises from which order?
From, my lord, 263 order, which I have taken my lordships now. That is 17/3/2014. Annexure F. Starts from, my lord, page 70. My page 70.
17/3/2014.
17/3/2014. Page 70. Para 5.
Now, after this, the matter went to
Tribunal.
assessing officer.
No, it goes to tribunal. They said this exercise of powers is 263 is bad. They said there is a change of opinion and the original assessing authority has looked into this specific issue. That was the contention made.
What is the date of the remand order by the assessing authority?
That is 263 order, my lord, 17/3/2014. My lord, I'll just clarify, my lord.
No.
An order of assessment came to be passed. Subsequent to the order of assessment, 263 order exercising revisional powers is passed. That came to be challenged before the Income Tax Appellate Tribunal. holding that it's merely change of opinion and could not have been done that?
No, after the Commissioner of Income Tax passed this order,
Please.
okay. When was the date? When was the assessing authority passed a fresh order? Mr. Padiwala, you have that?
Yes, sir.
What is the date?
28/12/2016.
28/12.
2016.
Okay. Now CIT appeals, it's pending.
Against that, my lord, against 263 order, I'll clarify. Against the invoking powers under 263 came to be challenged before the tribunal,
That's right.
not the subsequent order of assessment.
Very
passed.
right. We
Please,
got it. We are clear.
Please.
According to him, if ultimately their plea is accepted here, the subsequent consequential orders by the assessing authority of 28/12/16 becomes
Please,
infructuous. That's what he's saying. Okay.
I'll take my lordship's, my lord, whether the reasons.
Now
given-
your submission
reasons
is
given,
why the matter was remanded back. to the
please, that
assessing
is in
authority.
para 5, page 72.
5.2 para.
No, I'll read, I'll start from 5.
Okay. So you say no inquiry on this aspect?
No inquiry.
Yes.
I may be permitted to read, my lord. Sir.
Yes.
The SSC's contentions are carefully considered and not acceptable for the following reasons. 1. On perusal of the assessment records, it is noticed that the assessing officer has not examined and not applied his mind in respect of allowability of rate of depreciation on leasehold improvements. Even though the written submissions, it has been stated that the AO has examined and applied his mind in allowing depreciation at the rate of 100%, but wide order sheet noting dated 13/3/2014, it was admitted by the authorized representatives that of the SSC that this issue was not examined by the AO during the assessment proceedings.
Just 1 minute. Mr. Padiwala, tell us one thing. You are on remand 28/12 rejected 16 by the single. This appeal has been filed thereafter. This is 2018 appeal, no?
Yes, ma'am.
So it is after 2016 remand order had come.
That's right.
That's right. And you are challenging this 2014 order.
Right, my
No.
lords. Because even, my lords, will just see,
2014.
even the tribunal's order is dated February 18. So when the tribunal also decided that remand order had been passed.
Right, right. But by that time, the assessment order had come on
Yes.
remand.
Yes, ma'am.
Okay. So effectively, what you filed is against IT-ATO.
88.
Yes.
5.2, it was admitted by the authorized representatives of the SSC that this issue was not examined by the AO during the assessment proceedings. By not examining or by non-compliant application of mind on the part of the AO, I hold that the assessment order dated 29/10/2012 is not only erroneous but also prejudicial to the interests of the revenue. In connection, reliance is placed on Supreme Court decision in the case of Malabar Industries. The Honorable Apex Court has held as under an incorrect assumption of facts and an incorrect application of law will satisfy the requirement of the order being erroneous. In the same category, fall orders passed without applying the principles of natural justice or without application of mind. The phrase prejudicial to the interest of the revenue is not an expression of art and is not defined in the act. Understood in its ordinary meaning, it is of wide import and it is not confined to loss of tax. The scheme of the act is to levy and collect tax. The SSC's reliance on the IT-AT decision of its own case is of no consequence as the nature of expenditure on leasehold improvements may be different in each year and the same was not examined by the assessing officer. Similarly, the other decisions relied upon by the SSC will not also be of consequence as the facts of each case have to be considered separately. The SSC's contention that the assessment order is not prejudicial to the interest of the revenue as over 10 years, 100% would be allowed, is also not acceptable, as this would amount to postponement of tax liability spread over a period of 10 years. For the detailed reasons mentioned above, and as the AO has not examined and applied his mind on the issue of allowability of rate of depreciation and not restricting the depreciation to the applicable rate, I hold that the assessment order is erroneous as well as prejudicial to the interests of the revenue. The fact of non-examination of the issue has been admitted by the authorized representatives of the SSC, wide order dated noting so and so. Now, my lord, they themselves have said it has not been examined. That is what, my lord, the order noting shows. Then, my lord, the last sentence, important, my lord, in the circumstances, the order dated so and so is set aside with the direction to the assessing officer to redo the assessment afresh. In the case of depreciation on leasehold improvements, is to be restricted as per IT rules. The excess depreciation may be disallowed. That is, my lord, this paragraph has to be read, my lord, with 5.3. If they satisfy the assessing officer, my lord, that it is in accordance with, it has to be allowed, my lord, it has to be allowed. He doesn't give a direction, you just disallow it. What he says is, my lord, this expression has to be read with, my lord, para 5.3. 6 has to be read with 5.3.
Where does he say so?
He says, my lord, is of no consequence as the nature of expenditure on leasehold improvements may be different in each year and same has not been examined. All he says is to examine it.
The matter, in fact, according to you also, them also has been examined on 28/12/16 when the fresh assessment was carried out. Okay. Now what is?
Now, my lord, the tribunal, my lord.
Yes.
Lord, the issue before the tribunal was, that is in page 77, para, I'll start from para 3, my lord, 76. May I know?
Yes.
Subsequently, the commissioner on examination of records of assessment initiated revisionary proceedings under section 263 of the Act by issue of show cause notice so and so, as he was of the view that the SSC claim for 100% depreciation on leasehold improvements being allowed by the assessing officer was erroneous and prejudicial to the interest of the revenue, as the SSC was entitled to depreciation thereon only at 10% as per depreciation rules. The SSC filed his reply. According to the learned commissioner, the assessing officer has neither examined nor applied his mind in respect of allowability of rate of depreciation on leasehold improvements. Then, my lord, I'll read from 4.1. Before us, the learned authorized representative for the SSC submitted that the SSC furnished details called for by the assessing officer, wide letter dated 15/7/11, which included the details of leasehold improvements carried out, invoices of interior related work, sample copies of lease agreements entered into by the SSC company for some of the locations, etc. It is submitted that only after consideration of these relevant details, the assessing officer passed the order of assessment dated 29/12/2012. Now, my lord, on this issue, the tribunal, my lord, gives its finding from 6.1 and 6.3.
Yes.
And 6.3, my lord, its category stated, it is apparent from the perusal thereon that the 7 items on which details were admittedly called for were certainly not with respect to the examination on inquiry with regard to the SSC's claim for 100% depreciation on leasehold improvements. We find that the order of assessment for the year so and so is also completely silent on this issue. This has to be read with that observation, my lord, that they themselves have said it has not been examined, which I read, my lord, I think para 5.2 of the earlier order. That is 263 order, page 72.
Okay. That's all. Anything else, Mr. Patiwala, you want to?
No, just one thing. My learned friend keeps on referring to the so-called admission I had made. That was that there was no specific query raised that are you entitled to depreciation at the rate of 100%. But you asked me for the details of the expenses. You asked me for the lease agreements. What is the purpose of asking for those details if you're not verifying that? And my lords, please see page 50. Please see the show cause notice, which was issued after the assessment was framed to rectify the assessment. Specifically said here, particulars of mistake proposed to be rectified, excess depreciation allowed. And then I gave a detailed reply, and after that you accept it. You don't rectify your order because you yourself accept that there is no mistake apparent on record. If there is no mistake apparent on record, it is obviously that there are two possible views. Then 263 cannot lie. Because merely, the point would be this, my lord, merely because you don't make an inquiry, is that by itself sufficient to justify the invocation of 263? Or must the commissioner say that if he had made the inquiry, he would have not allowed this because of ABCD reasons? Today, he can't say that because the tribunal order is in my favor. He can't say that the officer would not have allowed it. Officer sub silentio has allowed it because of this reason. That's all.
Thank you. Reserve. Yes, say heard bill on the counsel for the parties, orders reserved.
Obliged.
Yes, next. Yes.
38, the Raghavendra. 38.
Please, your lords.
Yes.
This writ appeal, my lords, is filed questioning the order of the learned single judge. The issue that falls for consideration of your lordships is whether railways were required to reimburse me the service tax element, which I had taken on after the introduction of service tax on wet cleaning and wet washing, when the rates which were entered into the contracts prior to that reduction were all inclusive rates which did not envisage this subsequent.
Is this issue not settled?
My lords, it's already settled.
Which is the judgment?
Any number of judgments.
In your favor or in their favor?
In our favor, any number of judgments are there. The Delhi High Court, Kerala, so many other High Court judgments are already there. But what the bare facts, my lords, I may just state, we have 13 agreements which we have entered into between 2009 to 2011. Wherein, my lords, our job was to clean the bedrolls. It's wet cleaning and provide it to the passengers. And we are reimbursed a rate between 22 rupees per bedroll to around 25 rupees. That is the cleaning charges. Now, as per the tender, my lords, that's an all-inclusive rate because at that point of time, wet cleaning, there was no service tax. Now, 2012, my lords, they introduced the negative list service tax where except what is there in the negative list, everything else was tax, which your lordship is aware. Now, from that date onwards, I had to incur the service tax liability, which I have incurred, I have paid also, filed the returns. Now, I sent at least 6 letters. That is annexure C1 to C6, my lords. 6 letters. If before we come to those letters, my lords, it would be pertinent to know that unlike other railway contracts which go with the GCC, where there is an arbitration, etc. In this contract, my lords, there was a clause specifically for dispute resolution. That's at page 160, my lords. What it says, my lords, is that, may I read this out to your lordships? If any dispute, difference, or question shall arise between the railway administration and the contractor as to the respective rights, duties, and obligations of the parties hereto, or as to the constructions or interpretations of any of the terms and conditions of the agreement, as to its applications, except the decision whereof, if herein expressly provided for, then the same shall be referred to the chief commercial manager. 160, my lords, clause 42. Shall be referred to the chief commercial manager of Southwestern Railways, whose decision shall be final. Now, I write 6 letters to different authorities there, and the last of that also was to the chief commercial manager, and that is at page 193, my lords, asking him for the reimbursement. There was no reply from any of these authorities. Then a legal notice goes, that's at page 195, after which, my lords, they issued one letter, a very brief, short letter, which is written by the divisional commercial manager, 213, and this is what they say, my lords. They have said that all agreements mentioned in the notice under item are executed between senior division commercial manager and Jyoti, are prior to introduction of service tax. This is at page 213. No separate charges are collected from the passengers for supply of bedroll linen, as the fares being collected from the passengers traveling in air-conditioned classes are inclusive of supply of bedroll service. Railways have accepted all your bills as per the rates offered by you and accepted by us and cleared accordingly. This issue was raised earlier and we could not come to any conclusion in the absence of any supporting clauses in the agreement entered into. And this is what, my lords, because they have now referred it to the legal cell, they didn't take any action. This is what we are relying on, my lords, to say that if the clauses are silent, obviously reimbursement of service tax would have to be done, because the legislation itself came subsequently, and when the rates and other things were finalized and entered into, it was not in the contemplation of both the parties that service tax was chargeable. And therefore, it is but understandable, based on several decisions, that it should be reimbursed. This is why, my lords, we filed the writ petition also. What the learned single judge, my lords, however, felt was it we should have gone for arbitration. It's a contractual agreement between two parties.
Based on interpretation of 160. Where is the arbitration clause?
My lords, actually 160 was not at all interpreted, nor has he noted it in the order.
Let's see.
Unfortunately.
Let's see what does the.
It seems to have slipped his, probably in the order, my lords. Para 9 and 10.
But are you disputing there is any arbitration clause?
My lords, they see the general conditions of contract, GCC, when they issue a tender, there is an arbitration clause will be there, subject to being overridden by any specific agreements. If it is,
this GCC would be part of the agreement.
It is part of the tender, but here what happens, my lords, the GCC itself, the tender clause at page 393, I think I have set it out.
The contract is entered.
Yes.
Even GCC is made part of the contract.
Exactly. But this contractual clause on arbitration, which is there here, overrides that clause, the GCC, because they have a specific clause for this contract.
There is let's see the arbitration clause here.
Yes, my lords. That, my lords, is at page 390. I'm sorry, I think it's in the tender notice.
393, my lord.
393, it was.
Item O, my lord. Clause O.
Clause O.
Clause O. I
You
just
said
read
390.
The general condition.
393 clause O.
O, my lords. The general condition, lordships have got it.
No,
It's
390.
in 393, my lords.
Yeah, okay, the limit, no,
I'm sorry. Is the pages not tallying or something?
no, it is not. They are not. The 393, what we have is,
My lords.
the heading is Southwestern Tender Notice 22
Yes,
12
that's the
2011.
22/11/2011.
How does it,
Right.
Please come to clause O, my lords.
how does it start, my lord?
Oh, we
Oh.
thought 4.
No. O, my lords.
Okay, the general condition of contract of.
Yes. Contract of Southwestern Railway as in force for the time being and amended from time to time is applicable to this contract to the extent it is not inconsistent with the terms and conditions contained herein. Or in the special conditions or the same is repugnant in the context of this contract. So we are of this view, my lords, that this clause which is there in this agreement for dispute settlement will override the general conditions. Because this itself says this will apply only if something repugnant is not there or something which is different is not.
What is the repugnancy between this and
Yes.
GCC?
This is the GCC.
Just-
It's
I'm
part of
told.
GCC.
Yes.
Okay.
What
Just
I'm
pause
told-
there, my lord, before he continues. My lords, to read that, my lords will have to see 65B of GCC, which provides for the arbitration clause. It start off with the same clause which
This
he
is
read.
railways, na?
Yes, my lord, same.
Oh, 65B, okay.
It starts off with the same condition where the general manager has been given this authority of the chief administrator where to decide the issues. In case he fails to decide the issues, then arbitration comes. That's how it goes. It's not repugnant. I don't, sorry, my lord, I didn't, this was not the argument that was canvassed, so I didn't have that copy. But 60
Going force for the timing, the time to time, applicable to this contract to the extent it is not. See, what it says is GCC of works contract of this as in force for time being amended time to time, it be applicable to this contract to the extent it is not inconsistent
with the terms.
with the terms and conditions contained
Contained
herein,
herein.
or the special
Special
conditions,
condition.
or the same is repugnant in the context of the contract.
In the context, my lord, on all the three clauses, our submission is this particular clause, if we go back and see this clause, my lords, for this at page 143, seems to fit into a special clause just for this contract alone. I said some other.
You said 143.
It's there on 142, 160, several clauses, my lords. 142, your lordships is quite
142 and
paragraph 51.
Now, what is this part of? Is this part of?
Part of my agreement, the agreement that I have entered into with railways for this particular contract. What GCC is a part of the tender notice, my lords. But as a part of this contract, this is very specific. Paragraph 51. If any dispute, difference or question shall arise between the railway administration and the contractor as to the respective rights, duties and obligations of parties here, or as to the constructions or interpretation of any of the terms and conditions of the agreement as to its applications, then the same shall be referred to Chief Commercial Manager of Southwestern Railway, whose decision shall be final. Now this, my lords, therefore, read in the context of this clause and the letter which the Chief Commercial Manager issues to me saying we don't have any clauses in the agreement supporting a reimbursement, his decision has become final. I don't have any other recourse. I can only come to the report. Not only on the terms and conditions of this contract, but also on.
But what has been read by the learned single judge is the interpretation of 51. To
Lord,
mean this is an arbitration clause.
My lords, he has not referred to any of these clauses, unfortunately.
But how does he say there is the parties must
He says
explore?
all railways, you should go for arbitration.
That's all.
That's
on a general proposition.
On a general proposition. And he says it's contractual, you should go.
Very
And
good. That's
even
all.
there, my lords, there are any number of decisions now, I mean, then and now, which says Even if an arbitration clause is there, it can be entertained.
Very well.
One,
Just
yes,
one minute.
yes.
Do you dispute there is an arbitration? There is no, there is an arbitration clause?
Kindly come to page 75, my lord, clause 6. This is the first time, my lord, this argument is being canvassed. Before they learned single judge, they accepted those. Kindly come to page 75, my lord.
Now let's see which page you said.
Page 75, my lord.
75 or 77?
75, my lord.
Mhm.
Paragraph 6.
Now where is the arbitration clause?
In the general conditions of contract, which was part of the tender.
Which clause?
Clause 63B, it starts off, my lord, and 64B is the arbitration clause. 63B, my lord, where the general manager decides the dispute between the contractor and the railways. In the event he fails to decide, my lord, 64 comes into play where an arbitration sets. Now this contract, my lord, of a bench, that condition power which was given to general manager gets replaced by the chief commercial engineer. That's all, nothing else changes. Under the general conditions of contract, it is the general manager who decides the dispute between the contractor and the railways. But in the contract at hand, it is transferred to chief commercial manager. That's why that clause, my lord, was.
Let's see the clause. Part of GCC.
GCC is not produced, man. It's not part of the record.
Is that arbitration clause not here?
This is the only clause which we
Not
had.
part of the record. GCC is not produced.
Let's see the single judge order. Then you must have referred to it.
Yes, it was referred, my lord, it was seen. They admitted GCC is part of the contract since it's part of the tender.
We are not disputing the GCC is not part of the contract.
Only
We are saying that
that
our contract will override. There are two other grounds what grounds we took, I'll summarize, my lords. We said that this agreement has a specific clause. One.
Which agreement?
The agreement for service charges, which we entered in.
Which you entered.
Yes.
After the tender was given, LOI issued, then a contract entered.
Yes.
Very
In that contract, there is a specific clause for arbitration, which rests with the chief commercial manager.
In that contract?
Yes.
Where is that stipulation?
That is the one which we showed your lordships at page
160 and
160 or 141.
The argument they are trying to make, my lord, is.
1 minute, just
let me finish.
I'm sorry.
Let me finish. Huh? I don't want.
Clear on facts.
Yes, yes.
150.
Page number 142 may be seen, my lords. Paragraph 51. This clause comes in the agreement after all the tenders, everything. This is a contract which we enter.
That's only in the context of disputes.
Yes.
There is a internal mechanism which has been prescribed that to which authority you would go.
Yes. So we went.
You would go to that authority.
Exactly. And his decision shall be final, it says.
Obviously, to the extent of railways, it is final.
Exactly.
But if there is a larger dispute with regard to the contract and there is an arbitration clause, how would you reconcile this and the arbitration clause? For the ultimate dispute between the parties, maybe for the purpose of railways, it is final, but you are not satisfied. You will invoke arbitration clause.
My lords, we invoke the interpretation on different grounds. The grounds are, my lords, Article 14 challenge, which we said that this agency of the state had to act fairly, and that if there is a service tax levy which is introduced subsequently, then it ought to have been.
Then we have to see the arbitration clause. And did the learner single judge reproduce that arbitration clause?
No.
That's why, my lord, a question was put to them whether they disputed. They said no.
No.
See, you will find judgments.
Yes.
That clause of 51 is an internal mechanism which has been prescribed when during the performance of the contract, any interpretation of the contract comes about, it will be referred to the railway authorities, and that decision, the judgments are to the extent of railway, it may be final, but your grievance, because surely judicial review is open, the arbitration is akin, because it's an alternative dispute resolution, you will invoke arbitration and then proceed in the arbitration.
Yes, admittedly, we have not invoked that.
Despite there being a clause. That's his submission.
Yes, and we are saying that, my lords, the mandate of Article 14 and the presence, assuming for argument's sake, my lord, that I have missed the bus, which I have done. Now, am I precluded from filing a writ petition? It's a question that arises.
Sir Raghuraman, this issue is n number of judgments.
I will show your lordships those decisions
Yeah,
which
yeah.
are in my favor, my lords.
That's right. He will also show his.
Yes, yes, exactly, my lords. I will just show those decisions. That is point number one, because now, my lords, it's a question of fairness in dealing, because this amount, whether it is reimbursable or not on principles, is laid down by the courts itself, that it is reimbursable.
But we are in an appeal. We are only testing the order of the learned single judge.
Yes.
That's it.
All that we are saying, my lords, is the order doesn't delineate all these arguments, nor does it deal with any of the submissions that I made on Article 14. That is what is disturbing to me.
How is Article 14 in what context?
In the context, my lords, that the railways were to act fairly.
That's on merit. We are on the threshold. The
At the
threshold
threshold
is,
itself, even.
you should know. So no, sorry,
Yes.
we have to rephrase ours.
I'm sorry, please.
Now, between the parties, there is a contract
My lords.
which has a arbitration clause.
Yes.
Now that arbitration clause need to be invoked, or you would invoke a writ jurisdiction.
Yes.
Article 14 has no role. Article 14 will come to act fairly
Yes.
when it comes to on the merit of the dispute.
Your lordships is talking of maintainability of the writ petition under Article 226.
That's
Right.
very,
No, my lords, all that I'm saying, my lords, is the writ is maintainable if the railways, as an agency of the state, doesn't act fairly. Now, that is our submission before your lordships, which I have already filed the compilation before your lordship. I will take your lordships through those judgments as to when the writs were held to be maintainable. I'm sorry, my lord.
no, it's all right. Go ahead, go ahead.
Smiled in a way which.
No, why we are saying is a possibly related query from the court would be.
My lords.
Then all this arbitration clause in respect of governments and public sectors become redundant.
No, I
Though they are state or another authority or a local authority within the meaning of Article 12.
No, my lords, what I'm saying is this. I wrote letters. I don't get a response from them. I send a legal notice and then they reply to me saying, sorry, we don't know which clause is applicable in this contract. This is what they say. They say we can't find, which I read it out to your lordships. In the light of this, my lords, it is the party's interpretation is that since the railways are not acted fairly, writ is maintainable. This is all that we are saying, my lords. We completely leave it to your lordships to see whether in the facts and circumstances they have acted fairly, not fairly, even on merit.
That's on merit.
On merit. And maintainability, my lords, I'll show your lordships the decisions. Whether in such cases in contractual disputes, whether there is an arbitration clause, is it maintainable at all? That I will show your lordships. The lordships is convinced, well and good. Please, I've submitted the
Now
compilation.
let's a possible proposition from what you have
My
said.
lords.
Let's say what you are now canvassing is also a possible view.
My lords.
But the learned single judge has taken a one particular view, which is also a possible view. Why we in intra-court appeal interfere? That's another possible answer you might have to give. Maybe it's an erroneous, patently illegal, need to be set aside. But that's one interpretation, what you are canvassing. There can be another point which he can canvass, that it is when there is an arbitration clause need to be invoked, and that's also a possible interpretation. And the learned single judge has taken a view that it need to be sent, or the parties must be relegated to the arbitration process.
Then, my lords, I'll have to necessarily show your lordships that it is so unfair. It is so unfair that the reimbursements should be made. That's the only answer then I can have to your lordships. I can't go beyond that. I'll only have to show your lordships the precedent case laws and how it is so unfair that your lordship should step in and grant the. This is how we plan to proceed.
This is the best judgment.
My lords, there are any number of judgments in the compilation. My lords.
Give us the last one.
Can show your lordships, there are at least 1, 2, 3, 4, 5. The ABL judgment is easily the best. I have not produced it here because there are judgments which rely on ABL and come out with this. Unitech may be taken, my lords. That is pages 11 to 32, where they seem to summarize this. Please come to, my lords may come to page 23, Unitech decision. Starting from page 11, my lords, you'll find. Lordships have got the compilation. I hope the numbering is the same, my lords.
Page number 23.
My lord, page number 23. Sarah? The E1, my lords, that is maintainability of the writ petition under Article 226, which is what we are now before your lordships. May I read that, my lords?
Yes, yes.
Lordships have got para 38? Para 38.
38.
My lords. Much of the ground which was sought to be canvassed in the course of the pleadings is now subsumed the submissions which have been urged before this court on behalf of the state of Telangana and TSIAC. As we have noted earlier, during the course of the hearing, learned senior counsel appearing on behalf of the state of Telangana and TSIAC informed that the court to the entitlement of Unitech to seek a refund and not question nor the availability of the land for carrying out the project being placed in issue. Learned senior counsel also did not agitate the ground that a remedy for the recovery of monies arising out of contractual matter cannot be availed under Article 226 of the Constitution. However, to clear the ground, it is necessary to postulate that recourse to the jurisdiction under Article 226 of the Constitution is not excluded altogether in a contractual matter. A public law remedy is available for enforcing legal rights subject to well-settled remedies. A two-bench of this court in ABL International versus Exporter analyzed a long list of precedent of this court to conclude that writs under 226 are maintainable for asserting contractual rights against the state or its instrumentalities as defined under Article 12 of the Constitution. Speaking through Justice N. Santosh Hegde, the court held the following legal principles emerge as to maintainability of writ petition. In an appropriate case, a writ petition as against the state or an instrumentality of state arising out of contractual obligation is maintainable. Merely because some disputed questions of fact arise for consideration, same cannot be a ground to refuse to entertain a writ petition in all cases as a matter of rule. A writ petition involving a consequential relief on monetary claim is also maintainable. And if the lordships would see, they also say, please come to para 41. The lordship sees somewhere in the middle. It starts similarly. I don't know if the lordships have gone. The presence of an arbitration clause does not oust the jurisdiction under Article 226 in all cases, though it still needs to be decided from case to case as whether recourse to a public law remedy can justifiably be invoked. The jurisdiction Article 226 is rightly invoked by the single judge in the division bench of, in this case, where the foundational representation of the contract has failed. This is how they conclude, my lords. So I will have to, this is one of the cases. There are other cases on this. I will have to show your lordships that this is basically an indirect tax. When it came into my, when the contracts were entered into, there was no service tax. It can be passed on. The statute presumes that it would be passed on. Now, later on, there is an amendment which brings wet cleaning into the statute. Then what happens is that it is reimbursable. If it is not reimbursable, it becomes unfair. In fact, they quoted the decision of the Delhi High Court, which lordships has dealt with and distinguished, but it is actually pari materia with my case. So that I will have to go into that, my lords, and read out all those matters where the courts have thought it right to step in and award the amounts. Lordships will see there are at least from serial number 10 onwards, at least 5-6 decisions. In fact, Speedcrafts is on railways itself. But there are at least 6-7 decisions. If your lordships use MBL infrastructure, which seems quite, your lordships will see this at page 146. This very question was asked. The only issue, my lords, which arises for consideration before us is whether the appellant is required to reimburse the service tax which came to be levied post the acceptance of the bid of the respondent. Here, my lords, maintenance of rings and roads, there was no tax. There was a notification which was issued subsequently bringing it. So the question that arose, my lords, is that if the contract is all-inclusive price and subsequently an impost is introduced, how is it possible for there to be reimbursement? In fact, page 148 sets out the clause also of the GCC. Lordships will see page 148, para 3.3, the clause is set out. All duties, tax, royalties, and other levies payable by the bidder under the contract and under applicable laws or any other costs shall be included in the rates, prices, and total bid price submitted by the bidder. After having said so, my lords, what the court would say that, my lords, is that 3.4. Shall I read that, my lords? 3.4.
Yes.
My lords. A reading of the aforesaid clause clearly indicates that the respondent is required to factor in all duties, taxes, royalties, and other levies which were enforced under applicable laws or for any other cause at a point in time when parties had entered into a contract. The last part of the said clause makes that abundantly clear by stating that the rates, prices, and total bid price shall include all duties, taxes, royalties, etc. payable by the bidder under the contract, either under applicable laws or for any other cause. It cannot be said that service tax, which admittedly was notified on 27/7/2005, could have been in contemplation of the parties when the bid of the respondent was accepted. Admittedly, the bid of the respondent was accepted on 6/7/2005, which according to us is the date when the contract between parties materialized. The execution of the contract on 24/8 was according to us a mere formality. Therefore, the service tax which was notified on 27/7/2005 would not have been contemplation of the parties. We are also of the view that there is no provision in the contract which by implication could be said to take into account such an eventuality. Then, my lords, we come to para 3.9 on page 149 when they conclude, where they discuss further. They rely on 64A, my lords, of the Sale of Goods Act, and then they come to this conclusion. A perusal of the section would show that unless there is an intention to the contrary, if there is any change in tax, increase or decrease, parties have to bear the necessary consequences which flow from the increase or decrease in tax. Applying the same principle to the present contract, we are of the view that the appellant would have to bear the burden of service tax which was imposed with effect from 16/6/2005. Then they set out section 83 and the presumptions under section 12B of the Central Excise Act. It's this, my lords. There's a presumption that you pass on the duty in indirect taxes. That presumption comes from 12B of the Excise Act, which is made applicable to the service tax legislation. After setting that presumption out, my lords, they say this at para 4.1. Conjoint reading of the two sections would show that there is a presumption that service tax is required to be recovered from the user of the service. This, combined with the reading of the contract as executed within parties, brings us to a firm conclusion that the appellant would have to reimburse the service tax which has been imposed on the respondent. And then they give directions, my lords. This is a decision which is more or less similar to what we have. In fact, in respect of the railways itself, my lords, there is one decision in Speedcraft which is there, where at page 145, my lords, I'll only read the relevant paragraph. going, if your lordship sees para 13, going by the aforesaid precedent of Supreme Court, it is clear that the intention of the parties in the present case was not to pass on the liability of service tax to the petitioner. The petitioner was liable to the extent the obligations existed on the bid date, but not beyond that. As service tax was imposed subsequently, same would be reimbursable. So they're saying if it is something which is imposed later than the bid date, it has to be reimbursed. And then there are any other decisions, my lord, the Kerala High Court in Kishore versus Chartala. This is in a writ proceeding where they say, all these are renting, my lords. All these cases which follow, which I've said here, the Delhi High Court or the Kerala High Court, renting. When subsequently service tax came on renting, whether it could be passed on to the tenant was the case which the court said that it could be passed. These are my submissions. To say that on fairness, even if I fail to invoke the arbitration, on fairness, the amount should be reimbursed.
Yes. Tell us one thing. Are there any disputed facts?
Yes.
What are those?
Question is, my lord, whether we, the railways, are the end user or not. The question, my lord, is
No. To
That's the dispute.
determine the reimbursement of the service tax, which claim has been made.
my lords, the council read out the reply. my
Based
lord.
on stipulation in the contract. Okay. And there are no disputed facts which need to be gone into. Because surely a disputed question of facts not in a writ jurisdiction. These are the facts which need to be thrashed out before the arbitrator. And those need to be gone into before the claim of this refund of or reimbursement of service tax can be looked into. If that not being so, what is being argued is only this. It's only an interpretation of a clause. And these are the judgment whereas identical clause has been interpreted. There is not much to be actually adjudicated. So based on this judgment, 226 being maintainable, no, it is not excluded. Even though there is an arbitration clause, it can be considered by this court. That's in sum and substance they are.
This argument is flawed, my lord, for two reasons. The first, when they read out, my lord, are replied to their notice. They read out page 213. Pursuant to which, my lord, we refer to last paragraph in that notice, my lord, where we say we have sent the file for legal vetting. Not should find page 213, my lord.
Suit to be initiated in accordance with direction issued by the legal department.
Now, the next connection, my lord, page 214, is the reply notice which our lawyer has issued to them on a legal basis. Now, my lords, may kindly come to page 215 and 216, my lord. The last paragraph I just read, my lord, the most important point would be page 216, second paragraph, but I'll start from here, my lord, so it would be easier. It is to be noted that the price bid for comprehensive works of supply, washing and distribution of bedrolls to passengers of AC includes the rate inclusive of all applicable taxes and levies, etc. For example, your client quoted the cost per bedroll at rupees 2449 in the price bid, which means rupees 2180 is the value of the service, 216 is the tax, 215 is the education tax, and 3 is the secondary or the higher education tax. Therefore, the question of raising the bill indicating the amount of service tax separately on and about 2449 does not arise. Under such circumstances, the cost of bedroll would be 2752, white so and so, which is against the agreement executed between your client and my client for the comprehensive supply of washing, distribution, bedrolls, and so on. It is true that the service tax is an indirect tax and has been necessarily collected from the receiver of services. My client has already discharged the service tax portion to your client since cost per tenders quoted to your client, including the service tax portion also. Therefore, my client need not reimburse the service tax twice. Your client claims to reimburse service tax amount charged so and so. And such claim of reimbursed of service tax amounts to twice reimbursement of the service tax and also breach of Solomon undertaking and agreed terms of the condition. The valuation of service under the service tax governed by section 67 of the Finance Act 1994 as amended by the Service Tax Determination of Value Rules 2006. The passengers traveling in AC coaches are provided with bedrolls for which no separate charges are collected from the passengers. Providing bedrolls to the passengers who traveled in AC class is outsource of railways. The contractor to whom the bedrolls contract is awarded to the service provider, and the passenger who travels in the AC class is the service recipient. And the railways as pure agents. The cost of ticket includes the fare from place of boarding up to the place of destination mentioned in the ticket, for which service tax is levied on transportation of passengers in AC class today. Providing bedrolls and use of urinals and toilets in a journey are amenities provided to the passenger and do not form part of the total ticket. The provisions of urinals and lavatory bedrolls are for public convenience.
The contract is with you, na, with the railways. Na.
The problem is this, my lord. We are an agent. We transport a person from point A to point B. During this service, we provide bedrolls. We are not the end user. The question, my lord, who is the end user is not what's to be determined.
To whom the passenger is paying for traveling?
That is why, my lord, the learned order of the learned single judge becomes relevant. My lords may kindly come to page 77, my lord. 7, my lord. I'm sorry, 76, my lord. This was the case, my lord, where this argument was canvassed. We raised a preliminary objection, my lord, that there should be some fact-finding authority, which shows whether I'm an agent or the end user. This is what the Honorable Judge records, my lord, that the proceedings that happened on an earlier occasion. The Honorable Judge records that a specific question was.
There is a contract between the passenger and.
That is the problem, my lord. My lords might now take our objections. We contend, my lord, when this service tax came into play, service tax said that we are liable to pay 12% on the 30% of fare, to which we charge the passengers and pay it to the state. This, under the service tax regime, my lord, when service tax was brought into effect, service tax with respect to railways was only 12% on the 30% of the fare. This 12% was included in the fare. In the absence of we being the end user, we can't include the service tax which is imposed upon him in the fare because we are merely an agent. Supposing his concept that he, being the supplier or the service provider, was entitled to pay the service tax, he ought to have raised a demand which we could include on the end user.
You are claiming service tax on the ticket.
Only 12% of 30%. That not
from the passenger.
From the passenger. In the case at hand, there is no demand to him. He voluntarily makes a payment to the service tax department saying that this is the service I provided to the bedrolls. I pay this deposit. That amount he is claiming refund from us. Had there been a demand, he would be justified. Now, the contention we are urging is not that we are merely an agents who transport people from point A to point B. During this service, we provide an amenity of bedrolls and use of washrooms. This can't be taxed unless there's a specific provision which provides taxation for the railways to provide taxation on the bedrolls. We can't, in the manner of service tax which is paid by him, reimburse him. This, according to us, amounted to disputed questions of fact.
Is the passenger paying to him for the bedroll?
Now, my lord, service tax is being charged.
Huh?
Now, service tax is being charged. Because there's an amendment to the act, service tax is being charged. When this provision came, there was no service tax.
No, but they are
For this period, no passenger has paid it.
No, we are concerned with the period when the service tax was made applicable.
No, for this period, my lord, no passenger has paid service tax.
No, for what?
For the bedrolls. For the bedrolls. For the transportation, 12% tax is paid.
But what about the subsequent period?
For the subsequent period, there's an amendment in the rules, my lord, that we'll have to collect service tax for the bedrolls provided. For that, we are taxing. That's a subsequent period.
Where is the amendment?
Don't have it readily with me, my lord, but I can get it. That's
no, for subsequent period, you are paying the service.
We are collecting it and paying it. We are not paying it. We're collecting it. We always late on the end user and we pay it. We are merely an agents. That's why the rules.
From the passenger. And then depositing it for the bedroll.
We collect it, my lord, and make it part of the fare for transportation. That when the tender is awarded, that portion goes. Each passenger one.
You are including in the fare.
Separately, because there's a subsequent amendment. The only dispute is.
Does that depict bedroll also?
Lord, all service provided are included in this. I'm told, my lord, all servicing, but they are allowed to provide.
See that. We want to see that.
My lord, next week, not next Wednesday.
For your lordship's question, whether we collect anything separately, lordships will see page 136. The answer is there. The agreement itself. Please see clause 2A, my lords. The licensee agrees to supply the bedrolls without collection of any charges from the passengers traveling. We don't have privity of contract with the passengers. Our privity is only with the railways.
Anyway, you are giving these services to the passenger.
It's an amenity. It's not a service. It's an amenity which we provide.
It's a nomenclature only.
The reason this, my lords, may kindly come to page 146 of the judgment, my lord, which he gives, relies upon.
You do one thing, just place on record the subsequent what you are referring to. post that particular
My lord,
period.
this
where
issue
you
could be clarified, my lords. May kindly take page 146 of the judgment, my lord. Citations, some compilation they gave, my lord.
146.
Yes. My lords may see the first paragraph. This is a matter that did not directly go to the High Court. They invoked arbitration. It was the judgment that is passed pursuant an appeal under section 34, which was dismissed, under 37 appeal. Page 146 of the compilation of judgments.
They invoke arbitration.
Yes, my lord. Page 146 of the compilation of judgments that
Yes.
the first paragraph. This is an appeal preferred against the judgment of the learned single judge judgment. So by virtue of the said judgment, the learned
You
single
said
judge
page 140.
My lords, it's
of
come
the
to my compilation. I think
compilation of the
it's referring-
judgments, my lord, of the Delhi High Court that they rely upon.
Trying to say this, my lord, that it's not a writ proceeding, it is a,
Oh, it's a writ proceeding.
it is an arbitration
Where
proceeding.
the arbitrator gave a finding that who is required to pay the amount.
Very well. That's a different argument. We will hear you on that also.
That is what the learned single judge also first does, my lords.
No, we want to see, did you file this counter affidavit there before the learner single judge?
Yes, my lord, we had filed it. We had,
Is it part of this record?
yes, my lord.
Okay, we will look into it. Now, where do you say so that post particular
Post
period?
event, we have not said. This was only with respect, our statement of objection is only with respect to the period that was under dispute.
Now, tell us one thing,
My
Mr.
lords,
Raghuram.
my-
During the, did you paid the service tax to the authorities?
Yes, because you're on
Of the
self-assessment.
during the contractual period
Yes,
or part of the contractual period?
right, we paid as and when we had to pay the,
Right, was it for the whole period?
yes.
No,
No,
from
from day
2012.
one.
2012.
2012 onwards, when this was introduced.
And for how much period you paid it? The contract was till
Yes.
2013 or even thereafter it continued?
Thereafter, I think.
Not
it
2013 last one. It was
That
a-
was-
They have given the
So
bill-wise
for-
details, my
So
lord.
for a period of 1 year.
More than that. I
till
think.
March 2014, December.
So what is the period?
From 1/7/2014 to March 2000.
Page 165, my lords.
3 plus 4, 7, 16 months, my lord.
2 years,
16
my
months.
lords. 12, 13 and 13, 14. 2 years.
Si-
1/7/2012,
What is the page number?
165, my lords,
plus
annexure
4,
B.
9,
So it's
17.
55.
It's basically for the limited period.
17
2
months.
years. After that, they restarted to reimbursements. After that period.
That we want to see. Why you started reimbursing?
1/7/2012 to 31/3
separate-
2014, my lords. This is the period.
So July 12 to March
Yes.
14.
17 months.
My lords, 1/7/2012 is when the negative list was introduced.
That's right.
Yes.
Then March till 14.
Yes.
And after 14, possibly they started reimbursing.
Yes.
Okay,
Can't-
just say
can't-
that,
But I request my lords may not record my undertaking, my lord. I'll just, because these were the instructions that were given earlier. I'll have to re-get in my instructions.
no,
to
we
the-
will only say so that you want to take instructions. Just say that we have heard Mr. V. Raghuraman and the senior counsel for the appellant. Full stop. We have heard also Mr. So-and-so for the respondents who seek some time to take instructions. Okay, at his request, re-notify on. Just give it in after 2 weeks, 2 weeks.
11th,
11th.
11th, 11.
Great.
Deeply obliged.
Not 7/11, just do it a 1 week.
11/11.
Um,
11.
Next. Is there any other matter, ma'am? Just keep it with this. Ma'am, any other matter?
I think my lords had called out 27 2 times. They have not come. 27 was called out, I think, 2 times.
Yes, no one appeared for the appellant. I
Yes,
said.
yes. I should come that side, technically speaking.
Just say none for the appellant, re-notify. None for the appellant even on the second call. Re-notify.
25/11. 28, serial number.
Deeply
20,
obliged.
Serial number 28.
Appearing for the respondent. Raj, I'm sorry, I could not be present in the first round.
We'll have it some other day. Not possible today. Just say re-notify.
Alas, can I just pass on my judgment compilations? I will argue.
Keep it with you, we'll take it next week. Next time when we'll hear it. Just give it to him.
7th November. 35. Serial number 35.
Just say it's not possible today.
Yes, my lord. I also lead intelligence. It can be posted any time next week, my lord.
Pardon? We will see what really the board permits.
Yes, my lord.
Just say that, re-notify on.
2511, 40, serial number 40.
40, 41.
The appellant.
We'll have it some other day, maybe.
Any day convenient, my lords.
Just say
We'll take
that re-notify.
short amount.
Just say
2511,
That's 2511. I have some difficulty. If it can
just
be
say
only
whatever
11.
convenient, first week of December.
Right.
It's all, ma'am.
Next.
Yes, ma'am.
For pronouncement, serial number 1, Shri George Joseph.
In view of the above discussions, we are of the view that the trial court has rightly considered all the evidence and concluded that the alienation by mother and brother of the plaintiffs in favor of the defendant number 11 was for family necessity. Do not find any reason to interfere with the implementing judgment. Hence, a point answered is in the negative, and hence the appeal is dismissed. Cost made easy.
The amount is in department, maybe order to release.
There is issue to release the amount in favor of respondent number 11 to 13.
Is an application. Illy deposit.
ಇಲ್ಲ ಮಾಡಿ. This court directed as to KIDB to depart the amount, certain amounts were released to them. Still balance amount is there, madam.
File an application.
That's better, no? Next, ma'am.
Serial number 2, Shri Jaiprakash.
See, in view of our above discussion and conclusion, the appeal filed by the appellant is allowed with the following directions. We set aside the order dated 7/9/2018 passed by the court of this in IA3 in OS number 3496 of 2018. The suit OS number this is restored on the file of so and so court. The court shall proceed with the suit in accordance with law. The interim order dated 13/8/2020 passed by this court shall continue till parties appear before the trial court on 19/11/2024, when the trial court shall hear the counsel for the parties on the continuance of the interim order and pass appropriate orders in respect of the same in accordance with law. Respondent number 3, who was impleaded in these proceedings, shall be impleaded by the appellant plaintiff in the suit by amending the memo of parties in the suit and also by filing a fresh memo of parties in the suit. IA 1 of 2023 filed by the respondent number 1 in this appeal is closed, granting liberty to the respondent number 1 to file similar application for the consideration of the trial court. Liberty is also granted to the parties to file such application with such prayers as deem appropriate for the consideration of the trial court, and it goes without saying the trial court shall decide the same in accordance with law. The trial court records be sent back forthwith. Other pending IAs, if any, do not survive for consideration, and this time is. Thank you.